We are live. We are live.
Okay, thanks. Hi everyone. Sorry for short delay there. Technical difficulties. This is the first time we've hosted a town hall like this ourselves. So welcome. Thank you for joining. We have the update that we'll talk through first, and then we'll have some questions that were submitted that we'll answer, and then we'll open this up for live Q&A. We've got 2 hours. We do have a hard stop at that time today. I know people have had concerns about the notice period and the timing of this call. We've done our best. We gave 2 days notice of this meeting and hoped that was enough. We were conscious that this had been delayed for a period, and we'll talk during this about some of the reasons for that. And we really just wanted to get on with it, to be able to talk to you and address your queries. So we had hoped that 2 days would be enough. The 10 a.m. Singapore, 10 p.m. Eastern Standard Time is one of those things. It's very hard to find a time convenient to the world where we have a lot of creditors. So we've typically hosted in our evening and US morning before, and we thought it's fair to switch that so that some of the people it's otherwise been unfair to get a better slot, and we will continue to rotate it, and the next one will probably be the reverse again. We do intend to have another meeting soon, and I would say the first week of August or the very end of July. We want to keep this regular, and make sure that there are no further delays in this type of forum. So with that, thank you for joining. And George, if you could take us through the slides.
Sure. So first on the previous quarterly update is an update on the withdrawal progress. Previously, there had been some delay in the reactivation of withdrawals, which has since commenced in a limited capacity. This is limited and being carried out on a manual basis to prioritize security of these withdrawals to ensure that the withdrawals are being made accurately to the correct wallet addresses in line with the entitlements under the scheme. This has been slow, admittedly slow, and this is limited by the available manpower. To be able to accelerate this kind of process in a manual way would require even more manpower, and this would also result in significantly higher costs. As a result, we are not scaling up on additional manpower to run this manual process, and instead have formed a new development team, which is presently working on a solution that will allow DeFi payments to automate the withdrawals in a secure fashion. And this will allow, over time, once this process is finalized, a faster clearance of the remaining outstanding withdrawals. We expect to clear the remaining withdrawals within 2 to 3 months. We are pushing the team and hoping to get it done faster. Ultimately, we want to ensure that everyone who is entitled to a withdrawal gets to do so, and we'll provide updates as and when the withdrawal process is expected to accelerate. Speaking of a new development team, there's a slide on technological changes. 3 new developers have joined. They're called Vault Tech. The aim is to fix and maintain the current infrastructure on the web and the mobile apps. This includes the implementation of the new wallet system, which is a hot wallet system is more efficient than what we have presently. It'll be more automated and allow the faster and more efficient processing of withdrawals without compromising on security. The system will be built on top of Fireblocks, which is an industry-leading solution used by many of the top digital assets service providers and exchanges in the world. We are also undertaking an ongoing negotiation with our core wallet custodian service provider, Asset Reality. Their terms have been negotiated downwards and will be realizing about 85,000 USD savings over the next 12 months, and are actively negotiating the reduction of some of outstanding costs to them. There's also ongoing work in respect of a secondary marketplace for creditors of DeFi payments to sell their claims if they are so inclined. Have them listed at either listed and sold at the best market rate, or listed for a specific desired recovery percentage, so that they can receive offers which they may then choose to accept. This secondary marketplace aims to improve optionality for creditors, and participation is entirely voluntary. While work is ongoing and substantially advanced on this, it is not presently ready yet. Ultimately, this is pending approval from the scheme manager, because in our view, while a secondary marketplace gives optionality to creditors, is ultimately an option. It is not a mandatory term of the scheme. Certain mandatory terms of the scheme will be prioritized, and one such example is that of withdrawals, because creditors need to be able to withdraw the distributions made to them by DeFi payments, and as such, will be prioritizing the completion of all outstanding withdrawal requests on an automated basis before going live with a secondary marketplace. That's it. This secondary marketplace it does aim to improve the optionality available to DeFi payments creditors, and the terms of this creation of a secondary marketplace is done at a net zero cost to creditors, and the marketplace itself is cost neutral. We'll provide a further update in respect of the secondary marketplace when we have greater clarity over the launch date. The next section, as typically follows in these quarterly updates, is an update on the illiquid asset recoveries. Just a point to note. Owing to the delays associated with being able to hold this town hall, this set of slides is slightly out of date, and as such, I will be running through what is on the slide, but to the extent that we have more updated information, I will be flagging it as we get to it. First start will be counterparty A. As before, counterparty A and any details in respect of the ongoing arbitration with counterparty A remain under confidentiality, and we will not be able to disclose either the identity of counterparty A or any details of the ongoing arbitration. Broadly, we expect a resolution to the counterparty A arbitration process sometime within the next 6 months, by the end of 2025. As previously communicated on such town halls by Jason, the scheme manager, we do expect that enforcement proceedings will be likely, and this will have to follow the resolution of the arbitration following an award. Next will be FTX. We have saw the FTX claim. This transaction is pending completion, and unfortunately, this has been delayed for a period of time. It has not completed yet because the FTX administrator is has presented us with re-KYC requirements. This is not to say that that KYC had not been previously completed. It had been. All KYC documents had been submitted to the administrator. Administrator has accepted them and confirmed the KYC status. However, re-KYC has been recently made a requirement, and while we have submitted all relevant re-KYC information and gone through several rounds, the completion of the re-KYC process ultimately resides with the ability of the FTX administrator to get through the significant volume of re-KYC that is requesting from creditors of the various FTX entities. This also means that pending the completion of re-KYC, the FTX administrator is not able to make any distributions to creditors such as us. Because this resides with the administrator, we're also not able to provide a present estimated completion timing. However, we remain committed to keeping up with the process, ensuring that all re-KYC information is submitted in a timely fashion so that we can expedite this and complete the sale of the FTX claim. For this FTX claim, we expect net sale proceeds to be 8.6 million, which is approximately a blended 115% recovery on the .com claim and the EU claim. And once you factor in the repayment of the 0.8 million third-party claim previously approved by the board and the creditor representative, the net proceeds available for distribution estimated to be about $7.7 million US. On FlipVote, several hearings have occurred prior to this update. The first of which was on the 24th of February 2025, and the next one on 30th of April 2025. In both of these cases, our counsel came before the AAA tribunal and made its submissions and requested the release of the frozen assets on the basis that they have been frozen by the ED for well over 365 days, which is the statutory limit under the Prevention of Money Laundering Act, and as such, the continued freeze on these assets is unlawful. The fact that FlipVote has not been named as an accused in the ED's prosecution complaint, which we term here as the charge sheet. As such, we are not, FlipVote is not under investigation. And ultimately, FlipVote's assets were frozen as part of an investigation into a third party and not FlipVote itself. And lastly, the FlipVote's assets that were frozen have not been identified as proceeds of crime in the charge sheet by the ED. And as such, the ED has no basis to continue the freeze over FlipVote's assets, particularly in the context of FlipVote not being an accused. Unfortunately, at both these hearings, the AAA tribunal did not order the assets to be unfrozen. And at the latest hearing on the 30th of April, AAA asked the ED's counsel to clarify the exact details of the transfers that they allege were made to FlipVote. And as ED's counsel was not able to provide this information on that date, the AAA tribunal adjourned the matter to 15 July 2025. For those of you who have been following the progress on this FlipVote matter, it's clear that this has taken a significant period of time. And in view of this, we have been working with legal advisors towards filing a separate application before a special court in Hyderabad to secure the release of funds in an alternative legal strategy. For CoinLoan, this update sets out the breakdown of the assets that the bankruptcy trustee has secured. It was worth about 129 million in late April 2025, and of which 117 million is denominated in stablecoin, which is termed here as the first distribution reserve. This stablecoin was the result of a comprehensive liquidation exercise of liquidatable tokens held by the bankruptcy trustee. There also remains a separate balance of tokens worth 11.5 million US dollars, of which 5.4 million represent low liquidity tokens that can't be all gradually liquidated at once because of the low liquidity in the market. And as such, they'll be liquidated gradually into the market, and we term this the low liquidity reserve. Meanwhile, there's another $6.1 million worth of tokens which have been reserved and not liquidated into stablecoin on the basis that there are presently certain claims by creditors of CoinLoan against the estate on the basis that the tokens underlying their claim should be excluded from the bankruptcy estate because these creditors hold proprietary rights and claims over the tokens. And these are termed as exclusion claims. Until these exclusion claims are resolved in a court of law, the tokens are being reserved to address these exclusion claims in the event that the resolution results in a ruling that requires them to be paid back in token. In our view, this is highly unlikely. The structure of the legal basis and operational basis of the CoinLoan platform does not support such a claim. However, these claims have been put into court, and they will progress along the legal framework of the Estonian courts. So
George,
ultimately,
actually overnight, we had an update from the trustee that the 12 claims had been rejected by the judge, but that's not the end of that process. So the first judge has said no, which means it now gets referred to another court and another process. So it'll be ongoing, but that substantiates our view that they're not valid, but it will take some time to work through the Estonian court system.
thanks, Jason. Onto what we think will comprise the first distribution from the CoinLoan estate, and that will be the first distribution reserve, or at least a part of it. The first a more recent update compared to what you have on screen is the CoinLoan bankruptcy trustee putting forward a proposal to the CoinLoan committee, creditors committee, to liquidate facilitate a first distribution to creditors comprising 100 million USD, which will be distributed in euro. This is currently pending the creditor committee's approval. Some members have approved already, but not all have reverted just yet. So that is the latest in terms of the first distribution expectation. You'll note that there remain about 117 million, 17 million on top of that, which is being withheld withheld for now. And this is not to address the exclusion claims, but to address any claims that were submitted any claims held by creditors who are submitting appeals against the listing of creditors, which is separate from the exclusion claim point. The bankruptcy trustee is currently working through the detail and will shortly provide a breakdown to the committee for the approval to withhold the token stablecoin associated with these appeals. But once this is calculated, the remaining of the 17 million will also be distributed to creditors of CoinLoan. Over time, liquidation of the low liquidity reserve will also occur, and this will also add to subsequent distributions from the CoinLoan estate. Worth noting is the exposure to volatility. The first distribution reserve is currently in fiat. It's no longer in token, and as such, it's not exposed to the similar level of price volatility. The low liquidity reserve and exclusionary reserve, however, do have this exposure, and because the stable coin, which was in a US denominated stable coin, USD linked stable coin, will need to be converted to euro for distributions. There is some exposure to foreign exchange risk. Our latest understanding is that the bankruptcy trustee has progressed the conversion of a significant balance of the initially expected 100 million US dollars into euro, and is shortly to complete conversion into euro for the full balance. We do think that future distributions following this first distribution from CoinLoan is going to be possible. However, at this stage, we're focused on the first distribution, and subsequent distributions will follow in due course. And at this point, there's insufficient clarity on the quantum or timing for these subsequent distributions. The court process has also approved 221.7 million US dollars of claims, including DeFi payments claims of 36.4 million. This DeFi payments holds about 16% of the total claims against CoinLoan and is CoinLoan's largest creditor. So there are some calculations in this set of slides which will be used to explain the expected recoveries to PRT and the prorated track, and expected recoveries to variable recoveries track PRT, as well as the impact of the initial RDA on recoveries. For the purposes of those calculations, they run on the numbers set out here. However, because there have been some updates on the first distribution for CoinLoan, with specifically a revision of the 117 million down to 100 million, there's expected to be some changes, which will be in a better position to provide an update on in the next quarterly update. Terraform Labs has entered into Chapter 11 in the US. DeFi Payments has historically been able to prove about $30 million worth of losses related to the depegging of UST and subsequent collapse of the Terra Luna system in 2022. Ultimately, we expect there to be significant assets held by the Terraform Labs bankruptcy estate that will be distributable to creditors who are able to prove their claims. And the recovery percentage will depend on the quantum of claims that get submitted to the administrators and approved by the administrators. To that extent, the company has retained legal counsel in the US and has submitted our claim against Terraform Labs. The cost associated with this legal assistance has been low so far, less than $10,000, and it's not expected to rise dramatically. As mentioned earlier, the next three slides detail the math associated with the next distribution and recoveries to PRT and VRT respectively. It's important to note that the numbers here remain indicative for the reasons mentioned in the previous few slides. And timeline is also very much subject to what you see on screen. In summary, CoinLoan, the repayment of CoinLoan is, the first distribution from CoinLoan will be subject to the creditor committee's approval, which is in process and we expect will come shortly. The trustee then has to declare the dividend and make the distribution subject to the execution of this, which means that the timeline for the CoinLoan distribution is very much in the hands of the trustee and his administrative team. We understand that a significant volume of work has been ongoing to set up a system to facilitate this. This is being tested and is in progress. Potentially, the distribution for CoinLoan can be made in the next month, or next 2 months. We expect it to be sometime in 3Q 2025, given the progress demonstrated to date. For FTX, re-KYC has to be completed first. Now, the timeline for this is unclear because even though we have been submitting all requested re-KYC documents in a timely fashion, ultimately the FTX administrator is the party that handles the re-KYC, and this timeline rests entirely in their hands. However, once this is done, the secondary will have to complete the secondary debt sale to the finalization and execution of the definitive documentation. And once this is done, and the sale has completed, then the sale proceeds come to DeFi Payments. And as mentioned earlier in the slides, the platform is going to be updated. We think that it is important for each creditor to be able to view their individual percentage share of any illiquid assets, and this is expected to go onto the platform before the next distribution from DeFi Payments. For the purposes of the calculation, we are going to be using the assumptions on screen in the table at the top of screen, comprising 19.2 million from CoinLoan and 7.7 million from FTX for a total of $27 million, which will go to all creditors. I'm going to talk about the table at the top first, the impact of the initial RDA on the PRT and VRT claims. So just for those who are not familiar with PRT and VRT, PRT stands for prorated track, and VRT stands for variable recoveries track. Variable recoveries track was the default track for all creditors or DeFi payments under the approved scheme of arrangement. And PRT was an opt-out track for creditors who did not want to be on the VRT. The key difference is that the creditors on the PRT will have a fixed percentage share of claims at all times, whereas VRT creditors can have a changing percentage of claims dependent on the outcome of any reverse Dutch auctions that are carried out. When reverse Dutch auctions are carried out, creditors who participate in them successfully are basically offering their claims to be bought out at a specific percentage that's lower than 100%. And because they have accepted that, they get paid out at that lower threshold. They cease to be creditors. They write off the entire claim, and basically they exit the restructuring, leaving only VRT creditors who either did not participate in the the reverse Dutch auction, or did participate but were unsuccessful. But what this means is that the value of claims in the VRT, the variable recoveries track, lowers, which means that each remaining creditor in the VRT has a larger share of any distributions that are allocated to VRT creditors. And the next two slides intend to illustrate this. So from the top table, basically you can see that the prorated track represented 75.2 million US dollars worth of pre-initial RDA claims, and the variable recoveries track comprised 249.9 for a total of 325 million of pre-initial RDA claims. 23% for the PRT and 77% for the VRT. Now, after the VRT, the initial RDA was carried out, resulting in 32.9 million of VRT claims extinguished in initial RDA. This resulted in VRT claims decreasing from 249.9 to 217, and that's the right-hand side of the top table. You will note that the prorated track also was not affected whatsoever by the initial RDA, in line with the structuring of the PRT and the VRT in the scheme. So what this means is that basically when there's a next distribution, and in this example we use the 27 million that was mentioned earlier, you have the allocation of the 27 million from the pre-initial RDA claim. So basically the prorated track will get 23% of the 27 million, which is 6.2 million. If you look at the table on the lower half of the screen on the left-hand side, and the variable recoveries track gets 77%, that's 20.7 million. If you take that 6.2 million and divide it by the remaining prorated track claims of 75.2, you get a recovery of 88.3%, the right-hand side of the table below. For variable recoveries track, if you take the same methodology, basically 20.7, and this time you divide it by 217 million, and creditors in the VRT have a recovery of 9.6 million. This is big. The reason for the higher recovery in VRT is because of the 32.9 million of VRT claims that were extinguished and exited the restructuring in the initial RDA. As such, remaining creditors in the VRT get a bigger share of the variable recoveries track allocation of the next distribution. This table demonstrates what I just went through. The first line is basically what VRT recovery would be exactly the same as PRT recoveries if there had been no initial RDA at 8.3%, labeled as X. Now that VRT recovery is higher, 9.6%, that's why there's effectively a 1.3% upside from the next distribution, which is labeled as Z. Effectively 9.6% minus 8.3%. That's 1.3% higher recovery than obtained by VRT creditors than PRT creditors. This 1.3% is actually an overall 15.2% increase in recovery if you take the 1.3% and divide it by 8.3%. The last few bullet points on screen just talk about what I mentioned earlier. Basically, VRT versus PRT, which is the default, and which gets the benefit of any RDAs. Please note that there's no mechanism in the scheme that allows for conversion between the PRT and the VRT. If you're a PRT creditor, you will be on the PRT for the duration of the scheme, and the same goes for VRT creditors being on the VRT for the duration of the scheme. Now, the last slide that I will go through is a breakdown of the costs over the monthly cash flow estimate for April to June 2025. Broadly speaking, the operational costs for manpower, CEO, and board care remain largely in line with expectations, and so does engineering, product design, and data. There is an expected increase of $9,000 for finance and accounting support, and high engineering costs associated with ongoing work for withdrawal infrastructure. The next material increase in expectations on costs would be that of the custodian. This is of $60,000 for an annual payment that we are actively working to negotiate and reduce. There's an higher than expected legal costs associated with FlipVote, mainly because of the hearings that were held in recent times and preparation for the case in Hyderabad court. These are indicative estimates pending quotations from counsel. And lastly, counterparty A costs have been higher during this period of time. These costs are associated with certain milestones in the arbitration process for the legal teams, counsel teams, and tribunal costs. As before, we are not able to provide any further information in respect of the counterparty A progress due to confidentiality obligations. We've come to the end of the slides, and in line with the agenda communicated to all creditors, we will be moving on to pre-submitted Q&A. Before I go on, Jason, do you have any comments that you want to address?
No, thanks, George.
Okay, let's proceed. Thank you for sending through your questions for pre-submitted Q&A. We aim to get through this in fairly short order, hopefully within the next 20 minutes, so that we can dedicate a bit more time to live Q&A and have creditors ask questions live after coming in from the waiting room. So I have several questions here that we'll be able to address. There's one question in respect of the provision of the custodial agreement, which has not been provided to creditors and has been asked and has been requested of us. And also in respect of the evidence or documentation that supports the $0.8 million third-party claim in relation to FTX. Broadly speaking, the mechanisms set out in the scheme for the review and approval of such documentation resides with the board of directors, one of whom is the creditor representative. The board has reviewed the details in respect of the third-party claim, as well as details on the custody agreements. And this level of detail will stay at the board level, and it does not have to be distributed to creditors for individual assessment. Ultimately, the board of directors remains responsible for the administration of the company and the implementation of the scheme. And as such, the mechanism in the scheme sets out the review process being at the board of directors. There's a question on the use of cost reserves.
George, which importantly includes the creditor representative. That's the mechanism for creditors to get comfort that it's been reviewed by an independent party that represents them, and I can assure you that that's been done, and the review of those documents and issues received unanimous approval from myself, CEO, and the creditor representative.
That's right. Another question on whether any of the cost reserves have been used for activities related to a new business plan. It has not been. The new business plan is being developed internally by the new CEO. As such, the company hasn't incurred any expenses, external expenses in relation to this new business plan. There's also a question in relation to the independent audit and why the scheme manager and the board has not commissioned an independent audit of DeFi payments accounts. Ultimately, this is firstly, an audit is not statutorily required, and secondly, the focus of the company and the scheme manager team is to maximize recoveries from the source where the greatest recoveries can potentially be made, and that's the illiquid assets. Counterparty A, FTX, Flipvote, CoinLoan, Terraform Labs, all of these are being worked on concurrently and in parallel, and progressing these efforts takes a lot of focus and effort, and ultimately the focus that should remain on these illiquid asset processes because they represent the highest probability and likelihood of maximizing recovery for creditors.
Creditors will hopefully recall, I mean, in the scheme document, when one of the jobs of the scheme administrator is to put forward a proposal as to whether the restructuring is better for them versus a liquidation. The liquidation is the process where those investigations would be conducted, if any. And the work that we did leading up to that and putting before you and the court included the results of our investigations, which was that effectively there were no recovery options available to a liquidator. There were no transactions or information identified that would lead to recoveries for creditors. So, our work involved verifying the assets that were available and, comparing it to liabilities and looking at the gap, that led us to the insolvent position at the time. And there were no transactions that could be interrogated further that would lead to recoveries, and hence an audit now is really much the same thing and not necessary, and would be a cost money and time that would not lead to any further recoveries for creditors.
Another question. What is the process defined in the scheme to evaluate or replace the creditor representative? And how can creditors trigger a special resolution for this purpose, and what is the threshold? So the process defined in the scheme to effectively replace the creditor representative requires two things. Firstly, it requires at least 25% by claim value to be in favor of the convening of a scheme creditors meeting. And at this scheme creditors meeting, a special resolution needs to be tabled for the replacement of the creditor representative. The threshold for the passing of a scheme resolution is actually exactly the same as the threshold that the scheme required to be successful before on a creditor vote. And this is at least 50% by count, and at least 75% by value of creditors present and voting. So as previously communicated to creditors, we have been working on setting up a creditors only discussion. This progress has been delayed owing to the lack of operational support from the company in respect of setting this up. Ultimately, the scheme manager team sees the need to give creditors a forum of their own to discuss. And during the live Q&A, we're happy to take a temperature on how we should best go about doing this, whether we can hold this discussion or go straight to a poll. Excuse me. I've got a question from a creditor. What happens to the leftover coins when certain creditors' wallets are no longer active due to death or other unfortunate circumstances, and they are unable to withdraw? There is a mechanism in the scheme that allows unclaimed distributions to be rolled into a pot available to creditors who opt in to withdraw it at the end of the restructuring. In the case of a death or other unfortunate circumstances, typically there's an executor appointed over the estate of the deceased, and this executor will have to, if he wants to claim this creditor's share of unwithdrawn distributions, to basically approach the scheme manager and demonstrate his authority as executor of deceased estate, and facilitate the withdrawal on behalf of the deceased estate. In the event that he does not subsequently opt into this final distribution, then the tokens associated with this creditor who has unfortunately passed away will be added to the pot that will be distributed to creditors who do opt into the final distribution. I got a question about CoinLoan. This question is targeted at the volume of XRP tokens initially deposited by DeFi payments with CoinLoan, and which was according to this creditor in present terms worth almost 150 million US dollars, but with a significantly lower projected recovery, representing 10.6 million XRP. And his question is that if initially 68 million XRP was deposited with CoinLoan and only 10.6 million XRP appears to be coming back, what happened to the remaining 57.6 million XRP? And the easiest way to explain this is to draw parallels between CoinLoan and DeFi payments. So CoinLoan, much like DeFi payments, is what was an exchange, and the terms of the claims that CoinLoan creditors have against CoinLoan as an exchange were governed by the terms and conditions of CoinLoan, which form a contractual basis between CoinLoan and its creditors, much like how the terms and conditions of the Vault platform govern the contractual relationship between DeFi payments and its creditors. The claims that CoinLoan creditors have against CoinLoan are unsecured claims. They are basically CoinLoan creditors were owed maintain a claim for the value of the tokens deposited with CoinLoan at a specific point in time, much like how the creditors of DeFi payments held claims against DeFi payments in USD crystallized as at the 4th July 2022 with withdrawal suspension date. Ultimately, the claims that CoinLoan creditors, including DeFi payments, have against CoinLoan are not denominated in token. As such, they're not denominated in XRP, and we will not be getting recoveries in XRP. It's also worth noting that because of the operational structure of CoinLoan, much like exchanges out there that use cold wallets, warm wallets, and hot wallets, basically all user deposits are commingled in a significant manner, and as such, when CoinLoan went into bankruptcy, there was the XRP the significant volumes of XRP that had been deposited into CoinLoan's wallets were no longer there. They had been used in operations, used for the exchange operations that CoinLoan undertook. And as such, what the bankruptcy trustee had access to was the available token assets at the point that he took over as bankruptcy trustee and secured the assets of CoinLoan. From the same creditor, does CoinLoan's bankruptcy eliminate all recourse, even in the case of possible misconduct? So typically speaking, is the responsibility of the bankruptcy trustee to administer investigations and checks into potential misconduct and potential avenues for further recovery, which also means that just because CoinLoan is in bankruptcy does not mean that there's no further recourse. However, this is contingent on the outcome of any such investigations.
I think, George, we can say that it is not likely that there would be any further investigations or recovery, that the trustee has conducted some, and at this stage that there are no further avenues for recovery in respect of those types of claims.
That's fair.
Sorry,
next question.
Having said that, there were a couple. The solution was relatively cooperative. He's not in Estonia, which obviously limits any ability to cover against him, even if there were claims. And there were 2 properties that were in his name in Estonia that he did return voluntarily to the trustee, and that comprise a part of the recoveries that George spoke about earlier. They weren't of material value, like maybe up in the hundreds of thousands of dollars rather than millions.
The next question is on Flipvote. Is the situation between Flipvote and the Indian Enforcement Directorate, or ED, the result of a misunderstanding by the tribunal and the ED about Flipvote's operations? And if we are successful in court, can Vault seek reimbursements of legal costs from the ED? The situation is the result of a very wide net cast by the ED to attempt to lock down and freeze and secure assets perceived to be associated with an ongoing money laundering investigation into a third party. Unfortunately, the way that this net has been thrown has been so wide that many digital payment service providers, exchanges such as Flipvote has been caught in it. It is a function of the ED basically throwing a net as wide as possible, securing the assets, and then going through this extended investigation. Where the issue lies is that the investigation has progressed materially, and Flipvote has not been listed in the charge sheet of this investigation by the ED. So Flipvote is not one of the accused that's being investigated, and nor has it ever been investigated in the context of being an accused. And the proceeds of crime and the frozen assets of Flipvote have not been listed by the ED as proceeds of crime in their charge sheet. As such, we believe strongly that there's no further basis for the ED to continue this freeze, and particularly in the context of the freeze lasting far in excess of what is permissible under the Prevention of Money Laundering Act. We believe that this needs to come back and be unfrozen as quickly as possible. And the Indian court system has not progressed as quickly as we would have liked. As such, we're looking to approach a different court in Hyderabad to secure this unfreezing. Now, in respect of whether Vault can seek reimbursements of legal costs from the ED, we think this is highly unlikely, if not outright impossible.
I mean, court judgments typically, when you make a civil claim, you do get an award for costs. It rarely represents a material amount versus the actual costs incurred, and this is a bit different too. It's the Indian government that we're proceeding against under a freeze rather than a civil claim by us against them. So, yeah, extremely unlikely, unfortunately.
Now, onto the last question of the pre-submitted Q&A that we're able to address today. Vault's terms and conditions explicitly required 150% collateral for all loans. How then was the CPA loan approved with zero collateral? Just to clarify, the vault's terms and conditions require 150% collateral for loans made to users of Vault through the Vault platform. These terms and conditions govern the loan between a user of Vault that borrowed money from Vault on the Vault platform, and all such loans extended by Vault through the Vault platform will collateralize 150%. The counterparty A loan, however, was not entered into through the Vault platform. Counterparty A loan was entered into using a separate set of commercial terms under a separate set of commercial terms outside of the Vault platform, and as such, that transaction was governed by that separate set of commercial terms and not the Vault platform's T's and C's, because the party that the counterparty A is not a user of the Vault platform. All right. I think we are in good shape to jump over to live Q&A.
Yeah, there were for those creditors that pre-submitted, and there's a couple of questions that we haven't raised in this forum, but we'll revert to those creditors directly and discuss it with them one-on-one.
I'll let one or two creditors in from the waiting room, please.
Hi, Roberto. It's a familiar name. You can unmute yourself and ask your question. My apologies if my audio is not clear. There's a big thunderstorm going on here in Singapore at the moment.
Can you hear me now?
Yes. Hi, Roberto. We can.
Okay, good. I need to start by stating a couple of facts. I have asked you in previous meetings that the notifications for these town halls or any other meetings that we have take at least a week long. Can you agree with us that possibly the time is not sufficient to do it in 2 weeks? And today you come back around and you say that you hope that 2 days is good enough. And that is really a slap in our face. You already agreed before that this was not sufficient, and then you still do it again to us. So no good. That's just for the record. Additionally, I inquire you that we needed a meeting for only creditors. And once again, you said that sure, you'll look into it, work with it, responded to me an email or two, and then you left me hanging with no further responses. None whatsoever. So again, for the record, I'm still waiting a response from you or the team, and nobody else answered me, left me hanging. Not only myself. Also,
do you have a question, Roberto?
yes, I do, but I need to state these things so that we are all clear on how things are going on.
We're clear on your perspective, thank you. And if you were listening earlier, then we did address the creditor only town hall, and I'd be happy to talk about it further if you'd like to.
Okay, so I'm gonna start by asking you questions very specifically, and I will appreciate if you can answer with yes and no. So first questions is, are you aware
Roberto,
that after departing DFI payments?
I'm not being deposed, Roberto, and you can't dictate how I answer, but please ask your question.
Are you aware that after departing DFI payments, PTD, LTD, Darshan Batiha, and Sanju Kurian began working on a new crypto startup called DEFX?
Yes, I'm aware they have a new business. I wasn't sure what the name was.
Are you aware that in addition to the former Vault founders, a number of former Vault employees now work for DEFX?
Yes.
Are you aware that the number of the VCs of Vault, including Pantera Capital and more, are now VCs for DEFX?
I'm not aware.
Are you aware that some IPs, intellectual property developed and owned by the DFI Payments Vault, is being used by DEFX, namely the UI of the trading platform and the code behind it, which is identical to what developed at Vault?
I'm not aware.
Is there a licensing deal between DFI Payments and DEFX for using
No,
of this IP?
no,
And if so,
no,
no?
no. And
What
I
have
mean,
you
I think
done to enforce
IP.
Vault claims
Hold on,
to this
Roberto. I think.
IP?
Sorry. Well, IP is a fairly broad description, right? There's no licensing. There's no IP registered by DeFi. What exactly is it that I'm enforcing?
Well,
The ability
I
to
was
write
asking you,
the ability to write code. I mean, that's not something that's enforceable. DeFi Payments had no intellectual property that was registered or trademarked or has any licensing agreements attached to it. In effect, it didn't own any intellectual property.
I'm just going to go on to the next one for sake of time. In a Singapore, restructured creditors are in line to get money back prior to VCs, correct?
Prior to shareholders, yes.
In the agreement between DFI Payments and the VCs, what were the terms for this payment back on their investments? What was the earliest day they could get a portion of their investments returned?
George, I'm not sure if you know the answer to that, and it's not something that a scheme administrator or a liquidator would typically pay any attention to, because as you say, creditors need to be paid first, and then you would worry about shareholders, and obviously creditors are not yet paid in full, and therefore it's not something that we've looked into.
Yeah, that's right. And because of basically the scheme sets up mechanisms to make to recover illiquid assets, right? And all these illiquid assets go into distributed over time to creditors, and everything that's not distributed to creditors, sorry, distributed but not withdrawn, gets rolled into a final distribution that creditors have to opt into to get a share of. Effectively, unless significantly higher than expected recoveries are possible from illiquid assets, sufficient to fully repay all creditors on their claims and have some left over for shareholders. We are not looking at a situation where the shareholders are going to get any form of recovery from DeFi Payments under the scheme.
Has the current Vault board investigated the transfer of funds or assets back to VCs?
There have been no assets go back to VCs. Yes, the board has investigated that.
DEFX VCs include former Vault VCs announced June 12, 2025. Note that one of the VCs behind DEFX.com is Pantera. They also funded DFI Payments PTD Ltd. If Pantera lost money on the Vault deal, which they should have as a VCs, should not have been paid back prior to the creditors. There is a valid question as of why Pantera and other former Vault investors invest in another Batija startup.
Yeah, it's a valid question. I can't answer it. I can assure you that VCs did not receive any funds from DeFi Payments.
It's not it's not the only reasonable conclusion that these VCs got money back from Vault, and as such, they feel comfortable reinvesting with the Vault CEO again?
Absolutely not, Roberto. Shareholders did not receive any funds. They lost their investment. I mean, in my experience, VCs are not unaccustomed to that. They win some, they lose some, and they reinvest. And for whatever reason, they were comfortable with Darshan's explanations as to what happened, and they were prepared to reinvest. But I know nothing more about that.
In the documents creditors were provided for examination prior to the scheme vote in May 2023, there was a 34-page scheme of arrangement document that was included as an appendix to the explanatory statement. Is that correct?
can't recall the exact number of pages, but yes, absolutely, there was a scheme of arrangement document. That is the fundamental legal document that governs the scheme arrangements.
Given that that explanatory statement provided important information on how the scheme is to be implemented, is it not reasonable to conclude that that document is also legally part of the scheme of documents?
It is the legal document that governs the scheme of arrangement.
So
So
given
there-
this scheme of arrangements document is an appendix to the explanatory statements, and both are legally part of the scheme, are other documents also included as appendixes to same explanatory statements, not also legally or a
Yes,
part of the scheme?
yes,
Roberto, the legal document to the scheme is the scheme of arrangement document. That's the contractual basis. And the explanatory statement is the presentation of the underlying financial forecast, background context, and risk disclosures that typically accompany the scheme document in a restructuring under the Singapore scheme of arrangement. However, if you're asking about what is the contractual basis and what is ultimately binding, it is the scheme document and not the explanatory statement. The explanatory statement can and of course will be rapidly outdated following the issuance and finalization.
Are you aware that the financial projections and budgets are included as an appendix to the explanatory statement?
yes,
Are you aware that the said budget includes a line item for 400K to be allocated to audits?
yes,
Are you aware that prior to the May 2023 scheme vote and in response to numerous requests for creditors for an audit, all to be performed that on multiple occasions, numerous vault representative promises creditors that an audit would be provided?
I missed who you said that. I think Darshan said that, right? The director at the time.
Are you aware that the Vault CEO, Darshan Batiha, in direct one-on-one phone calls explicitly promised creditors that an audit would be performed and that he would make sure the CR approves the audit?
I believe I've seen, well, you told me about 9 times, and I believe I've seen information in relation to that, yes.
It is not reasonable that creditors were clearly led to believe prior to vote that an audit would indeed be performed.
Yep, there were indications given that would occur. And look, at the time, that was something that was discussed. It then subsequently became clear that it wasn't legally necessary, and that was one of the bases for doing it. And it wasn't capable of being done at the time. Efforts were made at the time, Roberto, by the directors to progress an audit, so to speak, with an accounting firm. They weren't able to conclude it. And by the time the scheme was then voted upon, it became redundant. Because as I mentioned earlier, we conducted investigations and there were no claims or further work that would have identified assets or malfeasance that would have led to recoveries for creditors. And therefore it was decided not to pursue it further.
But bottom line is, how is it not deceiving to promise an audit only to revoke that promise after the scheme was implemented?
The situation changed and it became redundant and no longer necessary. And that was explained why.
Is it not true that the IRDA Singapore Insolvency and Restructuring Act provides for creditors in Singapore restructured to have independent representation legally, and that is often comes from creditors' funds held by the company?
No, not really. No, creditors can appoint their own counsel or financial advisor if they want to. That didn't happen in this particular matter.
Are you aware that the judge specifically inquired about such legal representation, and in an affidavit Batiha countered that the company would represent creditors?
I think that's inconsistent. So the judge asked about legal representation for creditors. I imagine that's because he was being bombarded directly by creditors with emails and WhatsApps and whatever else. Whereas the judge usually would prefer creditors to have legal representation. Then you said instead the company was representing creditors. Well, the company's not representing creditors. The company's representing itself and putting a proposal to creditors on which creditors can then vote.
How could the company independently represent creditors' interests
can't.
using the same law firm that was representing the company?
The company is not representing creditors. I agree with you there. And if the creditors wanted their own representation at the time, then they were most welcome to get that. But I think some may have, George, but not many.
Describe what DeFi payments have done to ensure creditors have proper legal representation.
We don't have to ensure creditors have proper legal representation.
Do you not see the need for creditors to have their own independent representation?
It's not my role to decide what creditors want to do. They're most welcome to appoint their own representation.
But accordingly, would you approve that that the 400K that was budgeted for the audit be diverted to an independent legal fund for creditors? Said funds would be held in an escrow by a legal firm appointed by creditors for those sole purposes of providing consult to creditors. Would you support such thing?
No, in fact, I wouldn't be able to support it. The scheme of arrangement doesn't provide or allow for it.
But you have the ability to make those decisions, and why not would you support it if you see that we have that need?
I don't. The scheme of arrangement,
see we have the need as creditors.
The scheme of arrangement is a legally binding document that allows for how the scheme is to be managed, and I have to abide by that. And it doesn't allow for creditors' funds to then be used for that purpose. It would require going back to the court or back to creditors to vote upon that, so that it was clear that all creditors wanted that, or 75% of creditors wanted that. And that's not something that
you announced that the FTX recoveries have been sold on secondary markets. Creditors were repeatedly told that a poll of creditors will be taken to determine such support for this action. Why was this poll never conducted?
A decision was made in respect of the divestment of that claim. And it's not necessary to have a creditor vote for each and every asset. That's the responsibility of the scheme manager and in consultation with the board.
But you told us you were going to do something, and then you just decided not to, and we just were left in the cold, huh?
I think at one time there was some uncertainty in respect of the claim as to whether we were going to sell it, but ultimately the decision was taken by the board to divest that asset, Roberto.
Who were our FTX claims sold to?
Well, I can't divulge that because it's confidential, but it was done through a transparent auction process, and the counterparty is a very large financial institution.
When will you receive payment on these claims from the purchaser?
Well, it's being held up by KYC. We had previously satisfied KYC of the FTX administrator. Then the FTX administrator sent out a notice, I can't remember, 2 or 3 months ago, saying we need to redo KYC. Then they put KYC on hold. You can imagine they obviously have millions of things going on and people to deal with. That has just recently, in the last few days, recommenced. They've unsuspended that process, and we are resubmitting our KYC. How long they take to review that and confirm is in their court, but we're doing everything we can to do that as quickly as possible.
Are you aware that in the Vault affidavit submitted to the Singapore court, the FTX claim and amounts therein refer to the claim to DeFi payments, with no subclaimants such as DeFi Tech Europe and any of their counterparties or customers mentioned? In fact, the only mention of DeFi Tech Europe is with respect to them simply being a custodian, not an owner of any of the assets sent to FTX. How is it then that all of the sudden, a year after the scheme was implemented, DeFi payments revealed that a portion of the FTX recoveries previously reported as solely belonged to Vault creditors is now alleged to belong to a secret counterparty to the custodian DeFi Tech Europe?
As a result of the work done to collate the documents and prepare them for a sale and interact with the FTX administrator, it became clear that there was a trust claim effectively in that process. And so it came up subsequently when we were working through the claim in more detail and submitting the documents to the administrator, which hadn't been necessary much earlier in the process.
What is the identity of the alleged counterparty to DeFi Technologies Europe who allegedly had a legitimate claim to asset to be recovered from FTX?
Has that been disclosed, George?
No, it hasn't. It hasn't been disclosed. However, we can confirm that it is not any of the ex-directors of DeFi Payments, nor any of their related counterparties. Sorry, related entities.
And why is it not being released? What's the problem with that? Why couldn't we be more transparent?
Roberta.
Why do you have an NDA on that too?
That party, yes, of course. That party doesn't wish their name to be disclosed to the creditors.
A number of creditors have repeatedly requested this information. Why it has not been supplied to creditors?
It's not for each and every creditors to review all of the documentation. That's what the board is for, and that's what the creditor representative is for, and it has been reviewed in detail. The creditor representative absolutely in these things is fighting for your interests. He reviewed each and every document and he confirmed that it is a claim that needs to be paid, and therefore it has been.
VaultAction.org has a petition against Vault censorship and avoidance of creditors, including avoidance of the part of the current CR. Over 200 creditors have signed the petition. If I have been banned from posting from the Vault official Telegram group for over a year, and others have been in the same situation on multiple occasions, and other creditors have been in multiple occasions, and have submitted requests for details on the reasons of such bans, including evidence of these bans. Today, they still have not received no evidence and immediately request here. And now the immediate reinstatement to the forum of these creditors that continue to be banned from the platform. Also,
is there a question there?
Also, no, is a question, yes. Why these creditors are not being restated? Why are we not being transparent? Why we still continue to ban these people?
The last time this came up, each of those creditors was provided an opportunity to rejoin. I gave instructions and agreed with the CEO that let's let all of them back in. He contacted all of them, and you were provided an opportunity to rejoin.
Well, let me confirm to you.
He asked for people to confirm that they would abide by the rules of the forum, which is not to be, use foul language and be inappropriate or.
We still have several creditors that still banned and not allowed back into it. Not even once, even though you provided that direction.
The only reason, no, that's not true. That each creditor, is my understanding, has been invited to join. The only reason creditors haven't chosen to join is they don't want to sign the rules that govern the platform, which is to be polite and not abuse people.
What rule needs to be signed? Because I never signed any rules to begin with, not up to today. So now the people
Like
to join have
I
to
just
sign
said,
rules?
yeah, because people have behaved badly and were kicked out. We don't want that to happen again. That's all. So as long as they say, yes, I'll come in and I won't abuse people, I won't use foul language, I won't give people death threats, they're allowed to join, Roberto. I think,
Well,
Roberto, that we've probably, we've spent 21 minutes going through your list. Is there anything else that's a priority you'd like us to address? Because I think it's fair that we move on to other creditors, right? There's other people waiting to ask questions.
did Volt ever inform the Singapore court that it would send an email blast to all creditors with an invite link to join its reinstated Telegram forum?
No, the court has no role in this now.
Why didn't Volt ever send out an email announcement to reinstate forum to all customers?
My understanding is it was sent to those customers that were banned, not to everybody. There's no need to send it to everybody.
Well, I guess not all received it. And that's why you are under the belief that everybody was okay, I'm back in, but that's not the case. So I think it should be follow up. There's still plenty of creditors that are
Sure.
not able today to still join. Have you ever told COC members we have nothing to hide?
Probably.
If this is true, kindly provide creditors the following documentation
No,
in fulfillment
Roberto,
of your nothing to hide position.
no,
Alleged custody agreement between DFI
no,
payments and Shambatiha.
Roberto, sorry, I'll just jump in there. Like, we've addressed that, right? We're not providing that to all creditors. There's a mechanism in place approved by creditors and approved by the Singapore court to have a representative. The representative has all of that information. There is nothing to hide, and he is representing your interests, and cannot be provided to all creditors.
And then which creditors can that be provided? I mean, I would like to see them. How do I qualify or not to see such documents?
If the creditor representative is allowed to, that's the only part.
But the creditor representative does not respond to my emails and many other creditors. And there is no, and not here, and he is not here, and he has not been here, and creditors have not seen or hear from him in more than a year now.
I understand that, and it's a separate discussion, which I'm also happy to talk about. But yes,
where is our CEO? Where is the CR? And you say we need to work with them and through them, but they don't respond to us. So you're giving us an answer without an answer, because he's not there. He's not existent.
I don't disagree with that, Roberto. I agree. Let me just address that point, right? The delay in this meeting was as a result of their not wanting to do it through the Bold platform. We had to get this technology to be able to do it ourselves. They've obviously been invited. I wish that they would have attended here. They didn't wish to attend effectively because their view is that a live Q&A just like this is not necessary. They're very happy to attend and present the slides and deal with pre-submitted Q&A, but they didn't wish to participate in this live Q&A. I've tried to convince them that I think it's an important part of this process and it helps, but it seems I failed because they didn't accept my invitation. So I sympathize with that. That there is separately the motion from a number of creditors to remove the CR, and presumably that's a part of why he doesn't want to put himself in this environment. We have received, I think it was 7% or something, or 8%. We continue to tally those votes. We will continue to do so. That's not enough to call a creditor meeting. We are okay. We now have the capacity to convene a creditor only call if people would still like to do that. and we wanted to have this call and hear from people as to whether they still want that. Alternatively, we can just conduct a poll of creditors to confirm if 7 or 8% is the full number, or if we get more than that. If we get the 25%, then I'm obligated to convene a creditors meeting to hear and for creditors to vote upon that. But until we get that, I can't. So that's where we're at in respect of that process.
I'm the one that asked you to have that meeting so that we can get organized and possibly get to the
Sure.
thresholds and the legal things of the
Sure.
scheme to get there. But then you are the one that never responded me back anymore and left me hanging.
Hey, Roberto, you know, take the temperature down, right? I'm trying. I'm here. It's a bit it's taken longer than you wanted, sure, but that's because I've been trying to get the board, the CR and the CEO to agree to that and to convene the meeting. They did not want to. We have now, it's taken us a bit of time to work through to get our own technology and capacity to be able to do it ourselves, and we can now do it.
You want, okay, we'd like to have it done. The quicker, the better. So I would like you to commit to a date so that we know when that meeting is going to happen.
Let's just finish the call. Thank you, Roberto. Can we leave it at that so that other people can have a say? Because I'd like to hear from others as well. And then after we hear from others, we can then hopefully decide whether that's, I mean, you're saying you're one person, right? There's a lot of other people that were in that discussion. I'd like to hear if they still want that to happen or if they prefer to proceed with directly to a poll instead. I'm happy to go either way. So thank you, Roberto. MJ, would you like to unmute and ask away?
Hi, Jason. Hi, George. Good morning.
Hey, MJ. How are you?
I'm good. How are you?
I'm okay, thanks.
Quick question on the first slide that George presented about the claims process. So I saw the number 31,585 creditors have requested the claims. So does that include the folks who are part of RDA?
George, can you bring that up and
Yeah,
address
one
that?
moment.
Yeah.
This number?
Yeah, 31,585 creditors, right?
My understanding is that this number is just creditors who have come after the RDA, but this is something that I can check.
Right. And just to educate me, how come we have like number of claims higher than the number of creditors? Like, have creditors submitted multiple claims, or is it because of the different cryptos?
That's right.
Okay, got it. So
Oh,
technically,
me.
the reason, sorry. The reason I was asking is because, there has been a lot of speculation that the number of creditors is like 150,000. So is it fair enough to say that the realistic number is more closer to 32,000?
Yes.
Okay, thank you.
No,
Yeah.
let me just jump in there. This is the number of creditors who have made withdrawal requests, MG. There are
I understand.
150,000 creditors in total. The ones who have not made withdrawal requests are just they're still creditors, they just haven't made requests.
Understood. I'm getting
MJ,
there.
we're also still trying to get our hands around that, right? To work out how many more are likely, and we've been doing a bit of work internally to see if have people engaged in other ways other than submitting a withdrawal request, which would indicate they're active and alive and aware of this, and so we're trying to get a bit of a sense of that, including calling this meeting. We sent an email out to all creditors, right?
So you are actively trying to reach out to the remaining 120,000 odd creditors?
We haven't.
MJ, when we issue emails, sorry, Jason, let me quickly do this. When we issue emails, MJ, we issue to everyone. all 150,000 creditors.
Okay. So since you are doing some work on that, I'm not sure what exactly you're doing, but can we get a sense of that? What is the amount of claim of these remaining 120,000 odd creditors from the total claim amount? If that is not claimed, what are we talking about, and how much is in VRT and how much is in PRT?
Yeah, we're not sure at this stage. That's why what we're trying to work out.
Yeah, can we get that number, please, Jason?
When we get there, yeah.
Can that be prioritized?
Well, there's some other probably more important issues, right? That's relevant at the end of the scheme in just over a year. We're trying to get an idea about that now, but it's not. I wouldn't put it as a priority item. We're obviously trying to get distributions up to speed. We're trying to recover assets.
Yeah, but you are not involved in the distribution, right? Isn't this something that George can work on? What is he working on? Because
Many
honestly, I have
things,
not got any
MJ.
update from this previous town hall. I'll be blunt, Jason. There is no extra information since the last town hall in this town hall.
Yeah, I
So
understand. We don't have any. So, MJ, can I just, where you're going with this is you want to work out how much is left over that gets shared with everybody that gives you a
yes,
better dividend, right? I get
yes.
that.
Okay. So
We're
please actively work on that and prioritize that, please.
sure.
Okay. Now,
I just can't promise it quickly, MJ. It's actually not easy to do either, right? Like there's reach out, there's different levels of interaction, there's a lot of data. It is happening, but I can't promise it quickly.
I believe it can be done. It is not that complicated or time consuming. Okay. If I had the information, I could run it in half an hour and
Sure.
give you the results. Okay.
Okay.
So it is not that. And I would like you and George.
How much is not claimed is clear. How much is likely to be claimed is different. You're trying to form a view on how many of these creditors wake up between now and the end of the period and submit a
Yeah,
claim.
I'm
And so
just a
how are
ballpark
they?
highline number. It could be easily done, based on what folks have already put a claim, right? It's
Well,
just
the put a claim is already there in front of you. It's how many more are likely to submit a claim.
I know. So that's fine. I totally understand that there might be folks who might put the claim, but as of this point in time, I'm just trying to sense a gauge of what is the ballpark number we are talking about.
We
I'm not
can
looking for.
we can definitely do that. We'll
Yeah,
revert
that's what I'm asking for.
we'll revert separately after this for that.
Okay, I appreciate that. You mentioned in the update there are some 3 new developers added to the team. So how is the cost for that accounted for?
George?
AMJ, that's in the last slide. Let me jump to it.
What is the increase in the cost?
I understand it's about 6,000 USD a month. Can you see the slide?
Okay, and how long is it going to be? 6,000 USD?
That's a question probably better answered by Demir, because he's heading up the technology work and engineering associated with the vault platform. But at the very least, this needs to continue until for the next 2 to 3 months to ensure that we get a system up and running to automate the withdrawals at scale in a secure fashion.
Okay. Quick question on the secondary marketplace. How is that cost neutral, Jason? I would imagine a marketplace would definitely incur a cost to, um, you know, um, provide that kind of a infrastructure.
I'll take that one, Jason.
Sure.
It's cost neutral because the agreed commercial terms with the marketplace gets them to do the heavy lifting on the coding, the presentation of the marketplace. What we are doing on our end would be basically responding to requests in relation to confirmation of KYC, confirmation that a seller that's in a potential seller that's in contact with them is actually a vault creditor, confirmation of their account balances, which of course will be subject to agreement on behalf by the potential seller for such information to be released. And will also be involved following completion of any such secondary sale in transferring the value of the claim from seller to buyer within the database. The coding of the actual online marketplace, any outreach in relation to this marketplace, all of that, the cost associated with that is borne by the marketplace, that service provider.
So is there an approved list of these secondary market participants, I would call them, who are buying these claims?
My understanding is that there aren't any limitations on who can buy or sell. Selling is voluntary. If you want to buy claims, you can bid for it on the marketplace.
Except the creditor representative, he can't. He has information that others don't.
So I, as a creditor, could buy the claim of other creditors? Okay.
Yeah, the MJ, the main limitation is KYC, and I describe it as a limitation, but really it's just both the buyer and the seller need to be KYC with the platform, and the CR can't participate. But MJ, if you wanted to buy claims, you could.
And how are you going to handle the PRT and VRT?
It just transfers exactly. So if a PRT creditor with $100 claim sells that claim to the buyer, that buyer becomes a $100 PRT creditor.
Just a difference in pricing, right? Which is
Okay.
up to them.
Understood.
To
so it will be the bucket will remain the same. The PRT claim would go as a PRT and a VRT. Okay, got it.
Yeah.
Okay, so understood. Quick question on FTX KYC. So I believe the window had opened on March 3rd to do the KYC in FTX, because I'm enrolled in FTX as well, and the last date was June 2nd. So I don't understand what is going on with the re-KYC. Folks have already received claims for the 5 billion payout that FTX is paying. So what's going on here?
MJ, that makes the both of us. We were fully KYC'd with the administrator already, which is why we were equally surprised when the request for re-KYC and submission of information came back from the same administrator. However, there is not much we can do here other than to comply with the KYC requirements, which we have been.
Assuming the entity you're talking about is the same entity, MJ, because there's a few different parts of it.
Yeah, I'm talking about the same entity. And I don't understand. Earlier, you were mentioning that you had to disclose the trust claim for KYC. Why would they need to know the claim? They would just need to do KYC. And who is representing? What entity is representing in the KYC? Is it DeFi payment? Who is representing?
Not sure what you mean there, MJ. What you mean by trust claim?
You mentioned earlier something, Jason, that maybe I misunderstood. You said that everything was reviewed about the 800,000 claim.
When Roberto's question was, why didn't you tell us about that, much earlier? Well, we didn't know about it until we worked through the claim in more detail and were getting it ready to submit for KYC. That's all.
But you don't have to submit the details to FTX about the trust, right? Or to the
no, I don't think so. George would know better what we need to submit, but we only became aware of it when we went through that process, was my point.
So I don't understand. to the best of my knowledge, the only way to onboard onto DeFi payments was the Vault platform. So how did this trust get onboarded with the 800,000 claim that we are honoring?
This 800,000 claim is not with the Vault platform, MG. That's why he's not, this counterparty is not a Vault creditor.
So how was that money onboarded? That's what I'm saying. How is that claim valid?
It was between the counterparty and DeFi Tech, not with DeFi payments.
Yeah, but what was it? Did we get some services? How was that claim or
But they paid the money and it was being held on trust for them.
what, they paid the money for what? They invested? How did that money come
Yes,
into?
they invested, yeah.
Okay. And now coming to Flip Vault, why have we filed an application in Hyderabad special code of all the places? What's so special about Hyderabad? What jurisdiction does it cover?
Hyderabad.
I know, but
Yeah,
you know,
our advice, MJ, is that that's the best court where we have the most likely prospects of a hearing and a result. And there have been other instances where the Hyderabad court has stepped up in situations similar to this and given rulings to that would be helpful.
okay. But in regard to ED?
Yes, exactly.
Okay.
It's specifically in regards to ED.
Okay, got it. So I know you mentioned to Roberto that we cannot recoup the legal fees potentially from ED, but how about the interest on the frozen amount?
Yes, yep, absolutely. We will be trying.
Is that part of the application?
No,
George?
MG. The application is concise. It requests the unfreezing of the assets.
Why was that not added in the part of the application? Because we are talking about $20 million. That's a significant amount of money, and interest rates are very high in India.
I think the focus is just to get the money back. That wouldn't preclude a further claim for interest or legal fees, but I would suggest that the merits of that or the likelihood of that is going to be very difficult. But we can check with we'll check with our new legal advisors as to what's possible in relation to that.
Yeah, so this should have been highlighted by the creditor representative if he was truly representing my interest as a creditor,
That's exactly the sort of thing that he usually does. Yes.
but
I
he
don't
hasn't
bel-
seemed to have
I
done anything in this regard.
don't think he has raised that, but we will do so.
Okay, thank you. Quick question on CoinLoan. Um, I
MJ, sorry, I apologize. We do have to end at near 12, and there's a few other guys.
I
So
know I have a few quick.
I'm not ending you. I'm just giving you a warning.
I know. I have a few quick questions I think will be of interest to the remaining creditors as well.
Yep.
So, quick question on the coin loan. The first distribution reserve of 117.1 million. I thought that was in euro dollars. I saw on the slide it is USD earning 4%. How is the trustee putting it in USDC and earning a yield on crypto?
Through the custodian that's holding it. I forget the exact description, George. It was a PayPal product, was it?
Yeah.
Right?
Yeah. I don't have the details right now. But basically it is being run through, I believe I believe the custodian, and this is on a non-custodial basis, and effectively we own, sorry, the CoinLoan bankruptcy estate continues to own those the funds that are earning yield. But however, this is effectively old news at this stage, given that it has been has been withdrawn and substantially converted to euro.
Yeah, it was continued to be held on a custodial basis. The risk would be that, was it PayPal, George? Can't remember. That a very
No, it was in
No?
PYUSD, which is the PayPal stable coin. But that's just the stable
Yeah.
coin that it was generating yield in.
Yes, but the financial standing of the counterparty was strong enough for us to place the money there on a custodial arrangement and earn that 4%. As George mentioned, that's now being terminated and the money's being converted into euro and sent back to the trustee.
And I saw the name Copper. Is that the law firm which is having the custody of the euros now?
No. Copper
No,
or
Copper is
George.
Copper is the platform where is deposited to generate yield.
Oh, okay, got it. Okay. Yeah, I'm just concerned with so many counterparty risks. Why are we still having why is the trustee having
We 100% understand that, and the trustees similar, and it was an acceptable risk to take. And
Okay,
it's unwound now.
all right. Are you aware about the recent, I don't know how recent it is, but I was trying to keep myself abreast of the latest crypto laws in Singapore from Monetary Authority of
Yes.
Singapore,
Yes.
the crypto license. So what's your take on that, coming that June 30th is around the corner? What happens to DeFi payments world with that
It's a really good
requirement?
question. Really good question. I mean, the new business, I think that's been one of the major impediments to whether that can commence or not. That's in Malcolm's court. And when that legislation was coming, I said, please present your plan, but it's going to have to navigate that. And I think that's a big impediment. The other issue is, can we distribute these funds in the manner in which we are contemplating? And that is currently under advisement, MJ. It's not straightforward. There's various tests in relation to that licensing as to whether you're conducting a business, and we would argue that we're not conducting a business, we're just distributing back creditors' funds. But we may have to engage with the MAS here and or the court to clear the way to be able to distribute the funds.
Okay, yeah, technically, I mean, we do come under, I mean, we are still in a restructuring. Correct me if I'm wrong. It's a gray area, and I guess you need to get an answer from them, how it applies to a
Yes.
restructuring
But
company.
we agree.
Okay, coming to the board of directors, why is the CEO not present on this town hall or the CR?
I did address it earlier. I'll try to do so briefly again. I mean, the CR doesn't believe that he needs to be available for live Q&A. He's happy to present the slides and deal with pre-submitted questions, but he doesn't believe it's a part of his function to address live Q&A. And I would say for Malcolm, he feels like he's caught in the middle and doesn't want to take a side, if you like.
I didn't get you. Take a side for what?
Well, he doesn't want to agree with me. He doesn't want to agree with the creditor representative. I mean, I'm here answering live Q&A, right? So my position is that it's appropriate. We should continue to do it. The creditor
No,
representative
so
doesn't.
I don't get that, Jason. Everywhere you're saying that decisions are approved by the board, and now you're telling me that 3 members of the board are not on agreement and they cannot attend a town hall. They are responsible for that. They are getting paid for that. That's a responsibility towards the creditors. You replace the CEO, right? The old CEO with a new CEO, that he would be functioning better than the old. Looks like he's worse than the first one, because at least the first one showed up on a couple of town halls.
I've stated my position, right? I don't know what else I can say.
Board needs to be fired. They are not representing or doing anything, and we are not getting the details we need to get.
Well, there's the motion in respect of the creditor representative that I've also addressed, right? The CEO, I think, is fulfilling his functions as a CEO, and that's important. I'd be reluctant to disrupt that with another change, frankly. And we're doing our best to communicate with creditors, and hopefully that, for the moment, will.
Why don't you replace the
suffice.
CEO with a creditor as the CEO?
Well, I'm not. I don't want to disrupt the progress.
What value is he doing? What is he doing? What is Malcolm doing for the creditors? He's not coming.
Creditor withdrawals and getting the system ready to make distributions, Vold care and inquiries.
Yeah, but folks are not happy with whatever he's doing. He's not showing up his face. Can you please consider replacing him with a creditor?
All right. Thank you, MJ. Noted.
And one last question I have. Regarding the email you sent out, it seems like Kroll has got handle of all the email IDs of all the creditors. Is my understanding correct? So why was that done?
So that we could convene this meeting without it being convened through the Vold platform, because the CEO did not want to convene it through the Vold platform.
I see. Okay. All right. Thank you so much for your time.
Thank you, MJ. Appreciate it. James, you're next in line. James, can you unmute yourself and fire away? Well, I guess we can just do any of James, Bill, Rob.
Yeah, can you hear me now?
Yes, we can.
Okay, great. Thanks for doing this. I've been listening pretty well from the beginning and taken down a few notes. I hope we can get to most of this. First, I was hoping, can you elaborate on why the company resources are no longer available for communication with the creditors? Excuse me, like, the Zoom account, ostensibly creditors have been paying for that, and this you're hosting with a different one, different YouTube channel, different email address.
Yeah. I think I've said probably as much as I can really say about that. We weren't able to get consensus on the board for the conduct of this meeting, basically because the creditor rep didn't wish to participate in live Q&A, and therefore the CEO felt like he couldn't convene it.
I guess my question is, you as scheme manager do not by default have access to all the company's means to communicate with the creditors? You have your own?
I do now. I just had to get the email addresses, so now we can. I don't control the Vold platform, so to speak. No, the CEO does directly.
The CDO does. Okay. And was that the result of a vote or something more informal?
There's been a whole range of discussions, right? We're delayed in doing this, and we've been working to get consensus and a format. We just unfortunately weren't able to. There's been board meetings, a couple probably during that period, informal discussions.
Right, and the board is still just the three of you, is that correct?
Correct.
Okay. So regarding the numbers presented in the 6th quarterly update for withdrawals, I understand that, and this information is maybe old already, but 5,784 withdrawals are still pending. That was shared in the slides. And going back to this is a reference to the initial distribution in October of 23. Is that correct?
Yes.
Okay, so it's been like a couple of years, and there's some people who still haven't got their initial distribution.
Well, people submit new requests all the time.
Okay, well, I guess that's the second half of this, is that in the previous update, which was the 5th quarterly update in December, that number was 2,700.
Yeah, people
So
submit new requests at different times.
so if the pending withdrawals has essentially doubled since the last update, like how does that bode for the second distribution, which is, you know, supposed to be
Yeah, look,
imminent?
very fair question, right? And so yeah, that they accumulated for a period when we were stuck. Then we unlocked that, I guess, a couple of months ago. I can't remember. And it's coming down. It's coming down increasingly quickly as we've brought on those developers to get the systems improved. So it'll come down increasingly rapidly, hopefully, and we're preparing to have it much better for when we make the next big distribution to everybody.
Well, so
I mean, there's some. Sorry, James. Just let me, George. You can probably do this better than me, but there is increased automation now in generating, and the mechanism to distribute is now clear and can accommodate more. The present, so we're able to ramp it up now, basically, and we're testing how much we can do. So how quickly it will accelerate is currently a work in progress. The impediment is we don't want to, the creditor rep and CEO don't want to fully automate that. They do want some checks and balances on those distributions to ensure security, to make sure the money's going to the right people. Basically, there's an awful lot of, well, as you'd be aware, right, cyber fraud out there.
My understanding, wasn't all of that baked into the Vault platform from day one, and that's why we fought to get the...
Not to their satisfaction.
Well,
they identified some security risks that they wanted to address, and that's why we've been going through this.
Well, who is they?
The creditor rep, well, the CEO primarily. The
okay,
new
so
CEO, when he came in, reviewed the platform and identified security risks that needed to be addressed, and that's resulted in a change of the mechanism for distribution and now revamping the platform.
Okay, but it's been a manual process since October 22nd when the initial distribution was first announced. I mean, we received an email back then that there was a backlog and they were requesting patience. And that was, yeah, October of 23. And my understanding was that the whole benefit to passage of the scheme, as opposed to a liquidation or any other scenario, was that the Vault platform and its developers would remain in place and under the control of the company leadership, such that all of this could be expeditious. And it seems like even before the new board had a first meeting, there was a decision to do everything manual, and you know, all indications are that's been
yeah, I agree with all of that, and it's a frustration which we're working to address and fix so that the next distribution goes much smoother and quicker.
So what happened to the old development team, like that was supposed to be kept on the payroll per the explanatory statement, that we were going to keep, you know, a certain amount of Vault care agents and administrators and the development team so that all of this would be seamless? And now you're saying that we have a new Vault tech team. What happened to those guys we were paying from the beginning?
I mean, it's not easy, right? Life, you know. Do you want to stay?
They quit.
Do you want to stay in a dead end job? And yeah, what's the future? Where's your career progression?
Well,
yeah, people left.
Yeah, because it was relatively seamless that the Vault platform transitioned from, you know, the wallet, the trading, the swapping, to just viewing your balance, and then initiating the withdrawal. That, you know, they seem to have no problem doing that. It's just affecting the withdrawal on chain.
Yes.
And that was something that was seamless under the Vault platform. So I guess that's why I don't see, like, why couldn't we have just kept in place that system?
There were security risks identified that meant the CEO and the board wasn't comfortable to continue using that. James, can I suggest that we, like I mentioned, we intend to convene another one of these in end of July, start of August, probably the first few days of August. So we're going to have a much better idea at that time of where we've got to with the new systems and the solution. And I'll continue to work on getting Malcolm at the very least, hopefully, to attend that and address that.
Well, how much more time do we have for this call?
We're 1 minute overdue. It's midnight where George is. I think we can. I will obviously want to continue for a bit longer. I am not brave enough to end this and kick Bill Dalefeld out. You're still here, Bill. We haven't kicked you out. We're in control of this meeting. I take full responsibility for you getting kicked out if it happens. So yeah, if we'll continue. George, can you hang on for a little bit longer? I at least will hold on. So yeah,
absolutely.
Yeah.
I'll stay.
So we'll continue for a bit, but we'd like to try to draw to a conclusion.
All right, maybe I can just try and run through these then. So this secondary sale that seems to be materializing, are we hearing about that for the first time today?
No, it's been there. It's been on the agenda for quite some time. It's dragged a bit, and I'm sure that's been in other previous updates, that it was an intention. It's become real recently. It's fairly close to being able to happen, but frankly, I want to prioritize those distributions you talk about and make sure that that's fixed and that the distribution, and so if we focused on the other thing, it would distract from that.
Right, yeah, I don't recall hearing about a secondary sale previously, and I guess I'm concerned, how does that affect the company's intentions to hold future RDAs? You know, because I'm in the VR track and I specifically picked it because I was told I could benefit from greater recoveries when other creditors exit through RDA. And, you know, we should be staring at the third RDA at this point. Of course, we're not there, but it sounds like the company is giving these folks an off-ramp outside of the RDA.
Yeah, I think it just provides another option, may provide some liquidity for that outside of RDAs. I guess
creditors on the VR.
I guess that could reduce the liquidity in an RDA because other people have already exited. You're right, but it's much the same thing. Like you would be able to buy claims in that secondary marketplace.
But it's not the same thing. I mean, the RDA is very explicit in the scheme. Like it's, you know, a key component. There's probably 6 pages dedicated to the RDA, and now it sounds like you're throwing all that out the window so that people can opt to sell their claim to a third party and exit. You know, and how do I benefit from that as a VR track?
That's a good point, James. I'll take that on board. I mean,
yeah, I would suggest the board really.
Sorry, it's still a work in progress, and it's not to be implemented.
Okay,
I think you've raised a very good point.
If I could move on to like the audit, you repeated again that it's going to be of no benefit to the creditors at this point. I wonder if we could like clarify that Kroll in fact knew well in advance of the approval of the scheme that it would not be a legal requirement for the company going forward.
No.
Okay, but we actually discussed it, and you agreed with me that due to the small company exemption, Vault would not fit those requirements going forward due to the downsizing. And so you said on a town hall like this back in early 2023 that that's correct, we would not be required to have an audit. And yet it ended up in the explanatory statement forecast costs. It ended up in discussions at the 2 initial scheme creditors meetings. And it was in all the court documents that got approved by the court that $400,000 would be set aside, $100,000 annually for these ACRA audits. And
not an obligation under the scheme, though, James.
Well, I understand that. Being in the explanatory statement, it's not part of the legally binding side of it. But I just want all the creditors to understand that this is the choice of the company. I mean, would you describe audits as optional under Singapore regulations for companies?
Well, there's
Are
a
audits
statute, right, that governs whether you have to or don't have to.
Well, isn't it true that audits are mandatory for all companies unless they qualify for an exemption?
Yes.
And those exemptions are only granted in limited circumstances, and further that the company has to assert that it meets those exemption requirements and that it intends to request the exemption?
I'm not sure. I'd have to check. I don't think that's right.
James, yes, you're right, except that this exemption is not something that needs to be requested. It's an automatic exemption.
But it's not. There's a checkbox on your annual return that says we are exempt from the audit, and you check that.
Okay.
So that means that the company elected not to hold the mandatory audit because they're asserting that they qualify for a small company exemption. I just want everybody to be clear on that. And
okay.
Maybe, in fact, you can clarify which exemption Vald claimed. I mean, it would have to be a small company exemption. Is that correct?
Yes.
Okay, and has Vald claimed that exemption on every one of its annual returns?
Yes.
Okay, so isn't it true that if Vald wanted, or any of the directors wanted at any time, they could ask ACRA to appoint an auditor for the company?
Yeah. Sure.
Right. Okay, so there's no, struggle that the company had about trying to find an auditor. And
there was back at the time when there was an intention to.
So why did nobody request one from ACRA to be appointed?
We don't need to, and it would be a waste of creditor funds, and it wouldn't result in any potential recoveries for creditors.
It would be a waste of creditors' funds, but we allocated funds for that. We knew we were wasting funds for that money, if you want to use that term. I mean, I think we were.
A lot of things change, and there's no utility in it now.
But isn't that up to the creditors to decide? Like,
no,
how
the creditors decided when they voted on the scheme.
That's what I thought. But
if they had decided that it needed to be explicitly included, it would be in the scheme document.
Okay. Can you put a dollar amount on the total value of funds recovered by the company since July 4th, 2022?
George?
Recovered as in illiquid assets?
Yes.
I think the answer is none.
Yes.
Right.
Confirmed.
But perhaps you can elucidate us on the partial repayment that CPA made prior to the arbitration. I think it was like late fall of 2022. There was a partial repayment made on those loan terms.
That would fall into the assets that were paid out in the liquid distribution.
Right, but I mean, they were funds that were accounts receivable for the company post moratorium, right?
Okay.
And my understanding is that's the only accounts receivable that's been secured in the wake of the closing of the company.
Okay.
Is that accurate?
Yep.
And do you have a dollar amount for that?
I don't off the top of my head. George, do you?
No, and this is you're right. It rolled straight into the liquid assets, which were subsequently distributed. So
right.
that number is not incremental to the liquid assets. It's part of it.
Right, and there's been no other income, no kickbacks
Correct.
from advertising, efforts, no
Nothing.
no interest, no nothing. Okay.
Oh, sorry.
So
There's been interest on, funds held on deposit. Yes.
in bank accounts,
Yes.
would those be like fiat funds?
Yeah, the cost funds.
Oh, the cost funds. Okay.
Yeah. Yeah.
I guess, my wider question is like, I don't know. What has restructuring under the scheme accomplished to date that a liquidator couldn't have done, just as well?
That liquid distribution in fiat, in crypto, that would be the biggest advantage that already happened. I mean, the illiquid recoveries, I would argue, are being done. I mean, obviously, you might be disappointed with the time and amount and lack of information.
I'm in the
but
fence. Yeah.
I would argue that the recovery efforts have been improved and better because of the smooth transition and our ongoing involvement. But that's subjective.
But the recovery is zero. 2.5 years on.
Well, they're not going to be zero, James. I mean, you just sat through the update, right? There's good progress
That's
in
true. We
CoinLoan.
have an FTX report coming that apparently has been sold, yet the dollar amount of it is an estimate. It's like, how is it that you sold it, but you don't know the exact value of that sale? In the slide we just saw, it said recoveries
Sure.
estimated to be 8.7 million, something like that. But how do you not have the exact figure of what it is if it's sold?
George?
Yeah. The word expected is used there because it's still in process. At this stage, we don't think there's anything material that's going to happen to that number. There was a bit of uncertainty at one point in the negotiations phase, but the word expected is simply there because we haven't completed the sale yet. We
delay
do not
was a
think it's going to move
concern.
ship. Yeah.
The delay was a concern, James, at the time. Like the KYC and whether the buyer would look to renege or change or negotiate, that was we think we've squared that away and it's okay. But things that are outside our control, the administrator change in the KYC process, which has impeded that sale, we were concerned that would cause a problem with the sale.
I see. So the counterparty involved with DeFi Tech Europe has no bearing on this sale?
Well, it has bearing because it's one of the, but no.
It has no bearing on the sale itself, but it has bearing on the net proceeds from the sale, because a part of it needs to go to that.
We're in control of the sale.
Party play any role in the negotiations for the sale or the decision to go through with it?
No.
Can you clarify if that counterparty is in fact a corporation or an individual?
Can confirm that it's a corporation.
So I had thought that, in everything I'd read through the court affidavits, that all of Vault's customers or all of Vault's creditors were customer creditors. And there were no corporate creditors aside from CPA and FTX being, recipients of their counter loans.
Customers on the platform.
On the platform, but Vault as an insolvent company went through this restructuring through the court, not just on behalf of its platform users, but of all its creditors. Isn't that correct?
That's correct, James. Maybe you may have missed it a bit earlier in this town hall, but we clarified that this third party is not a creditor of Vault. It's a creditor of DeFi Tech. And DeFi Tech is not under the scheme.
I see. Is DeFi Tech still in operation today? Is it a functioning entity?
Yes.
And do they operate a website or what is the on-ramp for their investors?
I don't know, James. We don't operate DeFi Tech, and it's not under the scheme, so it's not under our supervision.
But it's a subsidiary of DeFi Tech or DeFi Payments. No?
I don't. No, it's not.
How would you classify it then? Like a sister company? Can you hear me?
Yeah, I can. Yeah, it has a common shareholder with DeFi Payments, but it's not a subsidiary of DeFi Payments.
But it's wholly owned by DeFi Holdings, the same entity that wholly owns DeFi Payments. Is that correct?
Yes.
So are not the directors the same?
Oh, between DeFi Tech and DeFi Payments? No, they're not.
DeFi Holdings, like the parent company.
I don't have the latest registry of directors for those two entities.
I guess
James.
I guess like I'm concerned because FlipVolt is no more a company under the Vault umbrella than DeFi Tech Europe is. Yet we're fighting enormously expensive court battles for FlipVolt, and they're even less affiliated with DeFi Payments and Vault than DeFi Tech Europe is. So how can it be that we know essentially nothing about DeFi Tech Europe's operations, but we're knees deep in FlipVolt?
What do we need to know, James?
Well, for one, we need to know why this counterparty didn't come up in the court proceedings anywhere, and it seems like he popped out of nowhere at the.
Look, it's as simple as this. I mean, popped out of nowhere. I've explained how that came to be in the process of reviewing the claim and submitting the claim and looking at the KYC, and then the sale. And yeah, it's as simple as there's a counterparty out there that has a valid trust claim to those monies that's been reviewed by all of the board, including the creditor representative. It's a legally binding arrangement, and they need to be paid. Even if that was Darshan, in Darshan's name, it would need to be paid. It's not him, but it doesn't matter who it is or why it's there. There is a legal obligation to give those monies to that party.
It's an entity, a business entity, correct?
Sure, yes, it is. But it doesn't matter who it is or what. It's a legal claim.
Right, because ostensibly they have some type of a signed contract, like a deposit agreement with Tech Europe.
Yes.
Yeah, and none of that can be divulged because it's not under the purview of the scheme or the directors of the company.
It is the directors of the company, and they've all reviewed it.
No, you just said that DeFi Tech Europe is a separate entity that's not.
They have a claim against DeFi Payments. DeFi Payments directors have reviewed the claim and accepted it.
But wouldn't it be the case that DeFi Tech Europe has the claim against DeFi Payments, not this unnamed counterparty?
Correct.
I mean, right. So how did it not come to light during the court proceedings that DeFi Tech Europe had a claim against DeFi Payments?
It didn't come to light. We didn't review it. We weren't aware of it. Documents weren't available. It was only when searches were made and information was dug out to submit it in the KYC proceedings of FTX.
Okay, and would
FTX had we had a very low understanding back at the time. I don't think we ascribed much value to it at the time, frankly.
Zero value.
Zero value. We had zero recovery expectations. So the 7.7 or whatever it is amount is.
Well, I'm sure some did, but the rest of us, fully expected to pursue those recovery. Maybe, it would be impaired. Maybe it would be a partial recovery, but it's certainly worth pursuing. And I think a lot of it.
And it was,
Sorry?
and we've now solved it, and it's a good result.
Right. Yeah, and that's one of the few things I think we can attribute to Demir, because he was adamant early on about pursuing that. Unfortunately, the same can't be said about the 9 million or so that was deposited on the Vault platform by customer creditors who weren't collateralized, and the the other 4.5 million, I think it was, that disappeared. Those are things.
We'll come back to you separately on that, James.
Okay. So what is the status of FlipVault right now?
I think we just went through that in the presentation, right?
I mean, like, as a company, is it still operating? Is it still owned by Darshan?
Yes. Ownership hasn't changed and it's still operational.
Okay. Because there was some confusion in circles I've been participating about. Apparently, he's had his corporate director ID number revoked, and there's been some speculation that there have been unpaid taxes on the part of FlipVault in India, and further speculation that FlipVault has already lost in court about their case with the government. Can you speak to any of that?
James, our understanding for the latter two is that they are untrue. And on the first point about the corporate ID, that's something we can check with Darshan.
Okay, but as far as you're aware,
we're not aware of it.
So the FlipVault case in the India court system is not currently on appeal?
No,
it is.
It's okay. Sorry, yeah, you're right, Jason. Go on.
I was just trying to clarify that there's a judgment already issued by a court against FlipVault.
Not our understanding, James.
Okay, so
nor should there be a judgment against FlipVault.
Yeah, we're not. FlipVault is not a party to any proceedings. Our funds have been frozen by the enforcement directorate. We've initiated legal action to unfreeze that. And
we've secured counsel who appears on our behalf in the Indian courts. How are we not party?
We have launched an action against the Enforcement Directorate of India to unfreeze those funds.
I see, but what authority does ED have to do that without a court order?
We would argue that they don't have authority, but they don't need a court order to freeze funds. That's how the Enforcement Directorate works, James.
So
FlipVault has been confirmed as not a party under investigation. The proceeds have been confirmed as not proceeds from crime, and we are fighting to have those funds released.
But how is it costing millions upon millions of dollars just to unfree those funds?
Because it requires court applications in India, unfortunately, to force the ED to do so, and we've been unsuccessful so far. The Enforcement Directorate in India is not a meaningful counterparty.
Maybe you can humor me momentarily. Like, hypothetically, if we did nothing in India for these last going on 3 years, would those funds still be frozen, or would they have become somehow confiscated or dispersed to unknown third persons?
They'd very likely still be frozen.
Exactly. So why spend the tens of millions of dollars just
because they will never
to be exactly?
It's not okay. You've gone from millions, which it's not, to tens of millions, which it's not. Okay.
Okay.
Because they would remain forever frozen, James, if we did nothing about it. 100%.
Yeah, but we're all well aware that the India court system works at a snail's pace. So what is the sense to go in guns blazing with these high-cost attorneys?
We've reduced cost and we've changed court. We're still trying and we're doing the best we can. It's not going to remain unfrozen it's not going to magically unfreeze itself if we do nothing.
Well, yeah, that's a given. But I mean, we can do essentially nothing and do it cheaply until things have progressed through the courts to where there's actually an argument to be made to get the money back.
We have strong arguments to get the money back.
Yeah, but it's the timing, right? The court is not ready to hear that because ED is still working.
They are ready to hear it. There's no.
Then why do they keep?
We argue that there's no basis for the Enforcement Directorate to freeze those funds. Unfortunately,
right, but it's not that
it disagrees.
Oh, okay, but ostensibly they wouldn't disagree in perpetuity. Otherwise, they would just confiscate the money.
All right. So you recommend a strategy of do nothing and cross our fingers that one day they'll give it back to us.
I recommend a strategy of like a legal assistant who goes in, submits the paperwork, sits through the hearing, and bills the 10 grand or whatever. Not the millions of dollars to litigate in.
I don't believe that's a viable strategy that would get creditors their funds back, James. But I've noted.
Right, because at this point in time,
it's been half an hour. James,
they would be effectively identical.
James, can we try to bring it to a conclusion? It's been half an hour overtime already, and there's two more creditors that want to have their say.
Right. Well, yeah, but I mean, you said earlier that this kind of takes us down the rabbit hole. And if Vault doesn't own its IP, then how could it be that we proposed a sale to Nexo? Like, what would they even be buying? Just
customers.
Just the customers?
Yeah.
Yeah. So such a sale not have included the platform. Like it makes no sense to me that you contribute a $0 value to a platform with 150,000 users.
They weren't interested in the platform. They were interested in the customers, and they weren't paying for anything. They were just going to charge the customers. And if the customers bought their products, they were going to, give a small slice of it to Vault. It was not a real offer.
But if Nexo had acquired Vault, would they not get the platform along with the deal?
It never advanced to those stage of discussions, and it's completely redundant now, right, James?
But like, had a liquidator taken over, they would have sought a buyer and marketed the platform as a valuable asset. I mean, how is the IP platform not an asset of the company?
They could have tried.
Yeah, and we just gave it away to Darshan to do as he pleases with the same people managing it, and the same back.
Not worth anything. It's not worth anything. I mean, there was a process there to try and sell the platform. No one wanted to buy it.
Darshan, have you visited the DEFX website? It's identical to the Vault Pro trading platform. Identical.
Can we move on?
And
James, there's just not much point here, right?
Well, the last thing I wanted to mention is whether or not you, as scheme manager, have the authority to unilaterally call a scheme creditors meeting and put forth like a resolution of your choosing for a vote.
No.
Is that?
No.
You don't have.
Meeting needs to be convened by the 25% creditors.
But isn't there a provision in the scheme? I don't have it in front of me, but I seem to recall that the scheme creditors meeting can initiate a scheme creditors meeting.
I think it's possible. George, do you know? Or?
Yeah, that's right. Confirmed.
Right, and such a meeting could potentially see a vote on a resolution to replace the CR.
It could, yeah.
Would you consider acting on that authority?
No, I mean, I'm if, for example, the creditors indicated, I mean, it's 7%. I don't think that's viable. But if it was 20-something% and close, but not quite, then yeah, I probably would.
Okay, so there's an avenue there if enough creditors get together. And have you communicated to the wider body of creditors how best to approach you about that, or is it just like a one-off email is the only way? Should we announce that any creditor who wishes at this point in time to pursue the replacement of the CR should email you?
You tell me, James. I mean, I've offered the all creditor call, which would mean an email from us to all creditors to attend that call. I'm happy to proceed with that. I'm happy to jump straight to a poll, which is quicker and easier to get an indication of creditors. And I'd probably rather do that. But you know, could you?
I know it's, maybe not possible, but could you commit to a timeline for when a poll might be live? And we could.
I think it's not that difficult, right, George? Like we could do that within the next, say month.
The next month.
We did it before using Google
Forms.
Yeah. So I don't think that's so difficult. We couldn't do it within the next, say, month.
Yeah, I think operationally speaking, that's possible. Well, what we wanted to understand from creditors was the appetite for that creditors-only discussion to actually chat amongst yourselves without us or the company present, to ascertain level of interest and appetite, and then from there go into a poll.
Right, because without some kind of a forum, it's hard to understand like the scope of it and how that would unfold over time. Because if the announcement for the poll goes out like a week in advance, maybe people are on vacation or whatever. So I'm speculating that there's an enormous support among the creditors to replace Demir, but they're not all at the same place at the same time saying the same thing and emailing the same people. So it's there's an undertaking there.
Happy to proceed with that call if you want, and then see what happens with that, and then you guys can feed back to us what happens.
Would that call be something along the lines of a town hall like this on Zoom, or do you know?
Yes, it would. Yeah, we'd use this same platform, right, George?
Yes.
Okay. Great. And finally, the at the last Q&A session, I think it was the end of February, I had sent an email to you that I was hoping you could forward on to Demir, and I never heard back from him. I haven't heard a response since early December.
He's definitely got your email.
Okay, perfect. That's all I wanted to know. Thank you so much again, Jason, for doing this, and apologies to Bill for and George, for dragging this out.
No problem.
That's all.
Thank you.
Thanks.
Okay, Bill. If you could unmute yourself, Bill. Here we go.
Yes, gentlemen, can you hear me?
I can.
Okay, and thanks. First of all,
I'll do you the discourtesy of turning on my video again as well.
I'm here in Asia, and thanks again for holding this meeting. A number of my colleagues with whom I correspond with have already raised a number of very cogent points. You've probably seen me chatting some things as well. It takes a lot of guts to sit there and take a lot coming at you, but that's what we expect. That's what we need, and that's what creditors deserve. Anyone who has an interest in a company deserves to be able to pose difficult questions. You go to a shareholder meeting, any kind of meeting of that nature, people will stand up on a microphone and ask tough questions. So given the fact that you guys are here, that you coordinated this, that you wanted to do that, and the other two members of the board, one is decidedly against it and the other's in the middle, does not speak highly regarding the effectiveness of the board. And as such, there's stagnation. Things aren't getting done. Decisions aren't being made that should be made, and things aren't moving along in creditors' interests. That's why there's been this call to replace the CR. So I do have some questions, and thanks again for having the floor. And I will respect people's time because I know I'm tired, and many of us have been here for a while, including George, I guess, in the East Coast, being in a very late time zone. Before I get to my questions, though, I just wanted to state that there is a creditor-driven site called vaultaction.org, which many creditors simply do not know about because, unfortunately, the Vault Telegram group is heavily censored and disallows mention of any sites and mention of any URL. This has nothing to do with not being polite or being vindictive or saying bad things about people. So I need to correct, with all due respect, statements that have been made here saying that people that have been kicked out of that forum are because of their bad behavior. That is categorically wrong. And I strongly contest that. And I ask, can I be reinstated immediately? I've asked this a number of times. I asked for evidence of my alleged bad behavior. I've never received a response because there is no.
Yes.
So my question is, can I please be reinstated to that forum? And in response to your requirement that I and others agree to rules, I'm not going to agree to the forum rules as stated because they violate the judge's requirements that were set forth to Vault many months ago, and including requirements for an unmoderated communication space. So when you have requirements in your guidelines that say that we cannot post links or pictures, it violates our freedom of communication, and it violates our ability to communicate with other creditors and share with them resources. Do you understand that?
Oh, I understand. So let me go back to one of your first points. Bill,
well, my question, I have questions. Can I please, will you immediately reinstate me to that forum? And if not, why?
I'm just going to address one of your comments earlier first about the board not functioning. It's clearly not, as I've expressed, in respect of creditor communication, right? Let's put that aside, but otherwise it is, okay? So in terms of the work that needs to happen for the illiquid assets and distributions and all the rest of that, we conduct regular meetings, we talk, we do things. There's no malfunctioning of the operations of the
arguably I disagree. I will disagree on a lot of things, but we can agree on a lot of things and work on a lot of things. But I will hold you account on that, Jason, because you've openly admitted that you guys are having to redo your entire development infrastructure because it hasn't been working.
But that's not because of disagreements between the board members, right? That's just because of what needs to happen in respect of fixing the distribution system.
Right, and if one board member doesn't want to make a decision to upset the balance with the other board members, that's a clear example of things not functioning properly and having stagnation. But irrespective, that can all be worked on.
I think so, and this is very particular to the way the creditor rep is interacting with creditors, which obviously is a concern. I have absolutely no issue in reinstating you, Bill. I don't have any issue with posting links. I think I don't see that should be one of the conditions. George, was that one of the conditions in what?
Yes, it is. Let's not waste time. I know the stuff inside out. I've already sent it all to you. In the interest of time, there shouldn't be any of these conditions. So please review it. And the only thing should be engaging in destructive bad behavior, which I agree. Okay. And in my response to you, Mr. Kodachi, I said that. Okay. All right, because I've run forums. I've been in the internet business since the early 90s. I've run forums for Adobe, FileMaker, Claris. I've been involved in Fortune 500 operations running high-profile forums. I know how heated things can get, but I also know that once you take people's voice away and you have all these stupid little stipulations, you rob them of their liberty and the rights. And right now, we do not have rights. We do not have freedom of expression. So I have sent very clear direction on how to revise your guidelines so they're complicit with the judge's requirements and they're fair. Yes, no one should be attacking one another. I was attacked viciously by so many creditors. I hated it. Evolved employees attacked me, Yash Kathari and others. We have evidence of all this. We leave that behind. We say we have free and open communication, just no one engaged in verbal attacks. We should be able to talk about Darshan and DEFX. We should be able to talk about anything, okay? Because, and so if we're in agreement on that, let's move on. Just reinstate me, reinstate everyone else, get rid of all the little minutiae that makes life so difficult for all of us, and we can proceed. I know I can work with anyone, all right? But when you take our voice away and you say, oh, you can't post this, you leave us no option other than to use other means of getting the word out. And so that's why I'm saying there are many creditors who are simply unaware of the vault action, which a group of creditors have put together and others, and they should be aware of that, all right? Especially when and if we can work together on things. So, so thank you for for saying that you have no problem reinstating me and others. It's not just about me. There's many creditors who have been censored, and that needs to stop. So, so we will have your commitment to change the forum rules so that they're in compliance with the judge.
Okay, I'm going to correct you because a number of times you said compliance with the judge. There is absolutely no requirement for the judge.
Yes, there is. Yes, there is. I will send it to you. I'm not going to stand for this. I'm going to, with all due respect, I'm not going to stand for this. There is a legal document sent from the judge. It was in the hearing where he said requirement. He said as pertains to requirements. All right. So my question is, if the CR is not performing, which you have alluded to, and many have alluded to for months now. You were nice enough to hold a February meeting with a select group of creditors. I was not able to attend because, once again, it was hastily planned. And again, sir, I have to correct you on this. You did not provide 2 days advance notice. That might have been when you typed it up and you thought you sent it. But I'm in Asia. I could send you my email. It was received by my email 11:50 p.m. June 18th, and then I woke up the next morning, June 19th. So it was 1 day's notice. All right, let's just be clear on our facts. We don't need to nitpick, but facts are important. So, so anyway, knowing that there's an issue with the CR performance, does not the scheme manager or other board members have the right fiduciary responsibility and obligation to take action to get that CR in compliance with the responsibilities, irrespective of demanding that creditors somehow find a way to contact other creditors, which they don't. We don't have a way to get this 25% threshold that is being required. So my question to you, sir, is you've already acknowledged that you see problems with the communications and other efforts of the CR. Can you not yourself do something to get him in compliance? And if he fails to, if he's been served notice that he's not complying with his responsibilities per the scheme, vote him out or call a scheme creditors meeting to allow us to vote him out. Can you not do that, sir?
I can do that.
Okay. Would you be willing to do that?
Not at this stage. I'm still continuing to work, as you say, to get his cooperation to improve his communication with creditors. And at the same time, we're exploring getting the creditor threshold to where you want it to be at 25%. And we're trying to facilitate that. You heard me talk to James before, right? We're happy to convene a call for you guys. Happy to give you that forum. We can now do that. I've been trying to get it done through the platform. We've now worked around that platform. So we will convene that call if that's what you want, or we will jump straight to a poll if you prefer, to give you that opportunity to get to that 25% threshold. I'm not minded to convene any meeting until you get at least very close to that threshold, because the prospects of it working, Bill, frankly, are low, right? Even if you get to the 25%, you've got to then get 75% to vote in favor. And if you
of those attending, and let's clarify, the June 9th email was unclear with respect to that. George did clarify here, because that was going to be one of my points. It's 75% of those attending. And
absolutely,
sir, you've what meetings that you have attended with creditors, way more than 75% at each of these meetings have called attention to the problem of Mr. Bootmer's performance. So the issue is, as you are well aware, getting people notified and so that they know that they have the rights to do this. Most people just don't have the time, and that's why we were requesting, please give us at least 1 week, if not 2 weeks, because many of us are traveling all the time or we're working.
We can do
1 or 2 days. 1 or 2 days notice. I know is wholly inadequate. We really need time. I was moving from one hotel to another hotel. I had to completely cancel all my plans so I could run to a co-working center. I'm in this little box just so I could speak with you guys. I know it's been a long time. I'm going to have some other questions, and thanks for the time.
And Bill, I'm sorry about that, right? That you woke up and got it right. We tried to give a couple of days. It's not enough, and we'll give more next time. Where are you, Bill?
I said I'm in Asia.
I know. Where?
I can work with anyone. I know I can work with you. If I was to be CR, can you work with me? You know how I operate. Can you work with me?
Yeah, of course.
Okay. I want people to hear that because
I was just saying,
sometimes there's a fear of change that people think, with history, blah, blah, blah.
No issue, Bill.
You have a job. You have a job to do. Many of us have been working tirelessly, not getting paid a dime, and putting out our own money to support resources because we feel very strongly about this cause. I will hold you to account, but I also be fair. I do not disagree. I do not agree with many of the positions that were taken, but that doesn't mean that I can't provide input to help us get to a better position. And you know that with me on the team, it will bring a lot of people who are sitting on the fence, totally against Wald, and knowing that we truly have a fair, honest, voice. So
more than happy to work with whomever the creditors decide, and absolutely including you. The only reason I asked where you are, Bill, is did you want to meet in person? I'd be happy to. I'm in Singapore.
Yeah, I have no desire to go to Singapore. That country screwed me and a number of others, but I'm currently in Kyoto, Japan, and I'll be in Hokkaido next month. But anyway, let's move on. Thanks for the offer, but I don't think we're there yet. We need to, as a group of creditors, get better transparency. You've alluded many times in the past. I've watched many of the town halls. Transparency is so important. Your lawyers bragged about that. Darshan bragged about it. Yet time and time again, there's so many NDAs and confidential things that you can't provide to us, always with an excuse. I would seek to change that because it's just a waste of your time. It's a waste of all of our time. Just provide the info if there's but we could talk more about that later. People want to know because, quite frankly, we have been out of being presented truthful information for so long. But that can change. Anything can change. So if there is a true effort to want to instigate change, it can happen with first a vote to replace the CR. And again, you acknowledge, just to be clear, Mr. Kadarchi, you acknowledge that if you yourself, as scheme manager, recognize the bad performance on the CR, you're trying to get that to change. How long has that been going on? Because this has been brought to the attention of you and others for many, many months, if not over a year. With all due respect, sir, how much more time will you give Demir to change before taking the action that really is required to help creditors?
It's a balance, Bill. And I'm trying to fill that void of creditor communication, right? So, but it's important that he does improve that. We've been working now for a few months where I feel like it hasn't been everything that it should be, and you know that as well, better than I do. I hope that it will improve shortly.
Okay, you mentioned that he's involved in some development work, some engineering work. I assume, I don't know if you or George mentioned that.
Yes.
That came as a surprise because Demir has been very clear in prior town halls that he has a very limited set of responsibilities per the scheme. That's all he's going to do. And he uses as an excuse for not responding to our emails. So it was odd to see that he's taken on additional work. But, I just wanted to confirm, is he involved with the dev team to assist with? Okay.
Yes.
That's not within his realm of responsibilities.
And but for his failings, he's extremely diligent in protecting your interests. I can assure you of that, in trying to maximize recoveries, reduce costs, enable distributions. He's actively engaged. He does work hard in respect of those. He just hasn't done as much in respect of communication as I would.
No, he hasn't done anything. Not responding to emails, flippantly making comments about. He called me an idiot in one of those COC meeting notes. We know how people talk to one another. You want to talk about bashing people? Just look at some of the evidence. But anyway, let's talk about some of my questions.
I'm just going to get some water, but I'm still listening. So keep going. Continue, Bill.
Was that George?
No, Bill.
Yeah.
It's me.
Okay.
Continue. I can hear you.
All
I'm
right.
just getting some water.
All right. Okay, so you mentioned that on numerous occasions that you did investigation, you found no malfeasance, therefore it would be redundant to do an audit. How can you find malfeasance without doing an audit? Because and it was acknowledged, and you covered your butts, if you will, in the scheme. It's very clear that Kroll is not responsible. It's because it received all of its information and numbers from Vault. So do you not understand the circular logic here? You're saying that
I do.
you performed an investigation, but you're not responsible because the numbers that were provided to you, you don't know if they're accurate or not. So how is that an investigation? That's why we need an audit. How is that not clear?
I'm responsible. I did an investigation, Bill. I received information from Vault, but I verified it to source documentation. So, my job as scheme manager is to look into that. So here's the scheme. Is that better for creditors? And here's the terms of it versus what would happen in liquidation. Now,
so you independently performed a Jason Cardacci audit of all the numbers that were provided to you. Okay, that was never revealed to us before. It's always been said no audit was provided. And you just said, I believe there's no malfeasance. So do you understand why people don't, it doesn't sit well if you just say, I believe. We need hard facts.
I understand. Let me give it some context, Bill. Like, people use the word audit, right? I mean, in my world, audit is some young kids ticking and bashing a few ledgers, right? It's not an investigation, and it doesn't necessarily that they'll come back with disclaimers of I didn't get this, I didn't get that. My job is different. I've been doing this for 30 years, right? It's to investigate situations like this, establish whether there is any malfeasance, and claims that would be available to be pursued in liquidation. If money had been, if something had been sold at undervalue, something had been to a related party, if money had gone missing that you could identify was missing and could be recovered in preference to creditors, that is what we were looking for, right?
Yeah. So, and I appreciate that, and I totally respect that, and respect your background. You're defining malfeasance in terms of money being misappropriated, which arguably there's evidence to support that, which we can talk about. But beyond that, is not malfeasance also in the category of making false statements, misleading and/or deceiving customers?
A little bit different, Bill. And let me I'll just finish that out. So we did enough work to establish that there wasn't a gap that was able to be clawed back, if you like, for creditors. So no transactions or missing money that could be sought to be recovered in an insolvency. That's that. The misrepresentation type claims, they're really for you rather than the company, right? Representations were made by the company to you, right? And it's or the directors made misrepresentations to you. That's a direct claim from you against the party that made that misrepresentation. So if that's the directors, you can go and sue Darshan or others for what they told you and misled you to believe. It's not malfeasance of the company itself.
We're getting into legal quagmire, but you're saying malfeasance is only when they take our money and misappropriate, which arguably they did. We could talk about what happened with CPA here in a second.
Claims that are available to the company.
You're aware of cheating, the laws against cheating in Singapore, okay? And is it not your responsibility as directors to make sure that the company, especially that you're going to restructure, has not engaged in cheating?
I'm not familiar with that term, to be honest.
Okay. And so, a fraudulent conveyance of funds is one issue, as well as fraudulent conveyance of information. But regarding, let's just go to the heat of the matter. If you want to, big picture, look at the Celsius. It's just one example of a major bankruptcy, right? If you just do a quick AI search or other analytical research that says how the alleged fraud scheme worked at Celsius. False promises and misleading statements. Celsius and Alex Mazinski repeatedly misled customers, number one. Number two, misuse of customer funds. Contrary to public claims, Celsius used assets for risky investments and to cover operational losses. And then 3, Ponzi-like operations. Number 4, false insurance claims. Every one of those criteria, which led to the U.S. going after Celsius, applies to Vault. There was false insurance claims regarding very visibly on their website and in emails that our funds were protected by BitGo. They were not. They moved our funds away from BitGo protection, but yet we're advertising BitGo protection. Ponzi-like scheme. Insufficient money to handle the payouts. What's a clear example of that? Sir, when Mr. Darshan took $202 million of our money out and sent it to CPA in a personal loan at a loan rate of 7% interest, so we're gaining that, and then got a reverse loan back at $35 million where we have to pay back 20%.
Yep.
Okay. It was impossible. He set up an impossibility situation through his misappropriation of funds for him to honor his legal obligation to run the business and pay us the 12% interest we were guaranteed per the terms and conditions. How is that not a fraudulent conveyance of money? How is that not setting up an impossibility situation, which he blames on market conditions, but he himself created this situation? So when you look at that scenario, sir, how can you explain that that is not malfeasance? It's not just bad business; it's actually malfeasance. How can you say it's not?
I think it falls into the bad business, and I don't believe that there are viable claims to be pursued. Be that as it may, claims have been waived by the company in the scheme, Bill. It was voted on, sanctioned by the court. There are not claims that are capable of being pursued. So we can talk about it all day, but it's now redundant.
Yeah.
And
so
I mean, the last point, just briefly, is Celsius and others, there were counterparties to go after. I mean, Darshan and co don't have funds that would have satisfied any of those claims.
He just started a business. He started a new crypto business. He has money. He has our money.
With other people's money, right? Like my assessment, believe it or not.
That's why we asked. That's why we asked, sir. We did the analysis. When we broke the story, vaultaction.org broke the story on DEFX nearly a year ago. We've been up on the info. We know what he's been working on. All right. And now to learn that Pantera Capital and other Vault investors are now behind him, how do we not know that they did not get early withdrawals? How far back did you go in your analysis of the withdrawals from the Vault platform?
They never received any payments during the entire life of Vault, Bill. No payments were made to shareholders during any of the life of Vault.
Now, when we say payments, we mean withdrawals or other favorable conditions or other special deals, any kind of remuneration. That's what you're standing by. Yep. Based upon your analysis, going how far back? 1 year, 2 months, 2 weeks from when you became engaged?
I just answered that, Bill. I just answered that. The entire life of Vault. Okay. Can we move on?
All right. Okay. All right. Thank you. Yes, I do want to move along.
I'm just telling you, my assessment is that there is no counterparty with means to go after here. And frankly, that's because they didn't steal the money. And I pursued people for millions, billions of dollars in other situations successfully, right?
Yeah. Well, but we have evidence of over 70 Vault creditors who had their withdrawal requests denied in mid to late June and early July, just prior to the July 4th freeze. And the June 30th numbers that are shown in the affidavit, one of the affidavits, are not congruent with the July 4th numbers that were later revealed, and which showed an inconsistency of, I believe, an additional $9 to $10 million being withdrawn by one of the top 10 creditors. And so when we raise these kinds of questions, and even in the, the process of we have the opportunity to ask the examiner to look at claims. We asked for an examination of some of these claims and did not get a sufficient response. So it is incredibly suspicious that just before the freeze, between June 30th and July 4th, there were millions of dollars withdrawn from some top creditors. And was that specifically investigated by you and your team, sir?
Yes.
Okay. And you saw no evidence of any foul play or someone getting advance notice including
Yes.
anyone associated with Vault.
Yes.
And the fact that, do you understand though, it's looked at as a conflict of interest if the person vying for the job to get millions of our dollars as scheme manager is also the one looking to see whether or not there's anything bad done. There's no independence there. So do you understand how that doesn't inspire trust if there's truly nothing independent in the review? And that's why we are seeking an audit, and we're promised one. So
Sure.
I'm just trying to help you understand. If we were working together, this is how I'd operate to explain. This is the creditor's mindset. Okay, appreciate being able to have this dialogue.
Completely understand, Bill.
Okay, got it. So I'll just move on. If you, I don't have much more. I'm tired. I'm sure you guys are.
Sure.
But George said that the sale of FTX is not finalized yet. So I posit, can we go back to the original plan of polling creditors to see if we really want this?
No,
and why not? Then let me ask you this, sir. What really is a timeline? Because I'm hearing all these different numbers of when the coin loan payables are expected. When I say payables, I mean the distribution. When the coin loan distribution is expected versus FTX. Does it not make sense to hold on to our claims and get both distributed at the same time? Because if we get one, it doesn't matter. We're not going to get the money until we get the other.
Absolutely.
So, but at this point, could you, because it was not clear with George, I took adamant notes.
Sure.
What right now is the worst case scenario for getting the funds to you from FTX and CoinLoan? When I mean to you, involves possession and DeFi payments possession. What's the worst case scenario in both of those instances, please?
On the FTX claim, can we undo it? No. There's a binding sale agreement there. It's just deferred pending this KYC. So I'll continue with that one first. So the KYC, we had cleared it. The administrator changed the rules. We've just resubmitted it in recent days. That I would hope would clear relatively quickly, and then that transaction completes. The worst case is hard to say because the administrator changed the rules on us once, and it's a large administration, and they've taken too long in certain areas. So, I now that it's open again, I would hope that should not be more than a month. But we're not in control of it, right? It's the administrator's process. We're doing everything we can as quickly as we can to give them what they ask for.
So possibly within a month. Well, but possibly within a month for the re-KYC plus the affirmation, if you will, affirmation of the agreement with the buyer, and then the buyer to get the funds, and then the buyer to send it to you. That doesn't seem overly aggressive. That's going to take more like 2, 3, 4 months, don't you think?
The completion process should be days. Like the deal signed, the buyer's got funds. It's a large financial institution, so completion, once the CPs, if you like, are satisfied, which is KYC, really should happen very quickly. So that shouldn't be more than a few days or a week. It's really this KYC process is the only impediment. And now I don't control that. That could take months, you're right, but it shouldn't take months.
Right. Okay. So, but the big issue is, when do we expect to get CoinLoan? Because that date was kind of variable as well.
CoinLoan, I'm going to be optimistic. I'm going to start with my glass half full, Bill. Those monies are being remitted as we speak back to the trustee's bank account in Estonia in fiat. He has about half of it in that bank account. The rest will come across in the next number of weeks. It's just waiting for those contracts to roll off that we're producing the yield. He will then have it in his bank account. He is working on the payment mechanism for instructions to remit the money. That should be done in parallel. So optimistically, that is July, right? But I've worked with this trustee now for a couple of years. Politely, he's a one-man band. He's never done this before. Nothing is complicated. Nothing is big. Everything is difficult and takes longer than it should, right? So his capacity to make a distribution to so many creditors, I worry about. We're trying to get on top of that. So I do think that there will be drag, but that cannot drag for more than 2 to 3 months. You know, that needs to happen in the next quarter. It should happen in the first month of next quarter.
Yeah, because where I'm going with this, I still don't, and I've never seen the benefit of selling our FTX claim, because by doing so, we're not making as much. Now you say we're making 115%. People don't understand that because it's 115% on a certain drastically reduced rate from a certain set of date, and it's not 115%. But regardless, it's for everyone to know, especially with all these delays and everything else. It calls into question the judgment made here amongst the board, maybe, and we've been fighting for it.
I mean, the claim's
to get our voices heard on this for over a year, and you said there's going to be a poll.
Well, let me, and I did, and I probably misspoke, right? I have unilateral authority to do whatever I want with these assets, right? Now, Demir doesn't believe that, but I do. I do not need board approval for any sale or anything, but I've been working to get consensus. Demir is very much aligned with you and in maximizing recoveries. And I wanted to sell FTX earlier, but we talked about it. It's an ongoing process. We then agreed amongst the board that we would sell. And
so why did you want to sell early? What was your reasoning?
My reasoning earlier was there was a substantial uncertainty with what was going to happen with the assets that were held by the administrator. We couldn't get any clarity on what they were holding. We knew they had this much cash. They had a large undisclosed position of investments that may have been crypto, may not have been crypto, could have gone up or could have gone down. So we weren't able of forming a reasonable investment view. We benefited from what had happened with what they had sold and had appreciated, and it was a good time to sell. So that was the back and forth. Ultimately, I think we pretty much sold at the top of the market, secondary market. The price is lower now than what it was at the time we sold. So I think we've done it's been a reasonable outcome. We just need to complete the sale.
Yeah, okay. The sale is finalized, but it's not complete, just to get our verbiage correct. So there is no misunderstanding on the part of creditors on this particular point. I want to give up my time to, it looks like, I don't know if it's the same Roberto that was here before that
No,
wants to speak
there's
again,
one more, just Rob Tuck, yeah. I think everyone else has had their say.
I got across, with all due respect, James and Roberto echoed many of my points. In fact, Roberto was reading from a draft list of questions that I put together. In the event I wasn't able to talk, thanks for giving me a platform to speak. To clear in summary regarding some of the action items we talked about, you don't oppose me being reinstated as well as others. To get that happening, though, what is it going to be the exact step? So there's no misunderstanding.
I'm going to review the terms and conditions with the CEO and make sure. I mean, I agree that it should just be, let's just call it bad behavior, right? In the forum should be unmoderated, and otherwise creditors can talk about what they want. They can't attack people unfairly, and that's the only sort of line I draw. And I'm going to have those rules. Try to have those rules moderated. I would need the board to agree, and then reopen the forum.
Yeah. Okay. That's acceptable. Just the word attack can be misconstrued by many people. So an insult, all that. So please err on the side of creditors' rights, because we're paying you. That's all we're asking.
My position last time, Bill, was just let everybody back in, right? And then let's see how they behave, right? And deal with it at that time.
That really doesn't say, well, I keep saying, let's see how they behave, like we've been bad people. Look,
there's been some terrible behavior in there, but I'm not saying that yours is, and what you're describing is okay with me.
It doesn't matter. The judge in a hearing said he fully realizes there will be bad behavior. I'll send it to you. So you're not standing on solid ground by keeping saying the judge.
You don't need to do it.
All right, let's get. So that's that action. Let's move on.
I want to be clear.
No. He said it as a requirement. He said it as a requirement. He used the word requirement. I have it on tape. Let's move on. So with respect to
Bill, do not talk over me like that and then move on. That's not fair. I gave you your say. Thank you. So I disagree. The judge asked Vold in respect of that unmoderated forum, and it was responded by way of affidavit, and then there was no further interaction with the court. So there's no instructional ruling in respect of that.
So
Nevertheless,
you're saying because
let's work on this. Let's work on getting this forum right and allow you people back in.
But to be clear, sir, your argument is that because the judge didn't respond to Vol saying, well, I don't like your requirements, that meant the judge approved Vol to do whatever they wanted?
I'm not saying he approved it. He just didn't do what you said, which is give an instruction and make it a requirement.
His initial guidance was a requirement. Vol responded, maybe the judge missed it. You guys gave him thousands of pages of stuff to review. Yeah, but you can't say that he permitted your
I'm not
revision.
saying he approved. No, he didn't do that.
Okay,
either.
So he did not approve these guidelines that you're putting forward. That's my position.
I agree with that. Yeah.
All right, let's move forward. Thank you. I have no intention of talking over you, but we got to get somewhere.
Sure.
With respect to something for the CR, you and George mentioned it'd be more efficient to just go right to a poll. I would tend to agree if there was certain systems set up that creditors were properly notified of what the options are.
Okay.
On Vault Action, there's a page that lists everything that I am committing to do if I was a CR. I think people need to see that because they might wholly agree with that. So that's what we need. That's what we want. If they don't know there's an option, they'll say, change isn't worth it. You said that it's highly unlikely there will be a change. With that attitude, we won't get a change. But
I'm not taking your view on this, right? Let's be clear. I'm not, and I'm trying to help. I'm not saying just my assessment is that passing that threshold will be challenging, but yeah, absolutely. Everybody deserves the right to try.
Yeah. So if we, a group of creditors, were to hold our own creditors meeting, not an official scheme meeting, I know we have the right to hold a scheme meeting. If you refuse as SM to hold a meeting to vote, we can hold our own. I understand that. The scheme gives us that. But, it's setting up a hostile relationship. We prefer to work with you guys. Okay. So working within the scheme, if we were to hold this discussion meeting, because we have the technology, we've done it a number of times, and we just said, hey, we're holding this meeting. Anyone is invited. Any creditor is invited to attend to talk whatever they want regarding replacing the CR, nominate themselves, and discuss what they want in a CR. If we were to organize this and send you an email announcement, would you then distribute it to all the creditors so they knew that that was an option?
I'd rather not do it that way because it's sort of just promoting you or your agenda rather than everybody's. I think what we would do is give plenty of notice, right? Like you say, set out that this meeting's being conducted. Tell people that if they want to participate, they're obviously welcome. If they want to nominate themselves, they're welcome. If they want to explain to other creditors, well, they'll be the world's best CR at that meeting. They're most welcome. It's your meeting, right? You can do what you want, but we'll just frame it so that people are ready to express that at the meeting, and then everybody can turn up and you can have that discussion.
I agree with that approach. It has to be fair for all. I completely agree with that. The question is who's going to run the meeting. You posited, I don't know how much we can say about. We privately talked about it. I don't have a problem if you or George actually runs the meeting, as long as creditors can say whatever they want. And I think that would be more efficient than any creditor getting the microphone, because as you said, that would give undue influence. So I would posit the best thing would be, if you're so willing, either yourself or George, make an announcement that there will be this creditors discussion. You will moderate it and try your best to give equal time to anyone that wants to talk. And that could then lead to a poll if there seems sufficient interest.
Okay. I mean, my natural assumption was you wouldn't want us there so you could talk freely. And that's why we went to the second nominated creditor rep. What's his name, George?
Johnny Edelman.
Johnny to conduct it and play that role so that you could speak without interference.
And I don't know if you've tracked the whole history and what statements have been made about this or that, but I would have run for CR back then, but I was moving my house, number one, and number two, I had appointed David Kim of Cordamentha, And then as a last minute change, Vald and you guys, you changed the rules. And after that, there was infighting within the creditor community, jostling to get someone, and it just was not healthy. And so that was a last minute change. I don't know who spearheaded that, Darshan or someone, but it created an unhealthy environment where creditors were going after one another to try and get that position.
Right.
It would be best to do it in a healthy manner where the scheme manager or George, you don't need to talk much, but just sit there. You're running the meeting. You allow people to talk, and you just maintain decorum. That's it. It shouldn't be Johnny. It doesn't need to be me. Someone's not a creditor. Let us talk, and then we can go from there. So
let me think about that. I think people will. This has been a fun one, Bill. I think people will cast aspersions on me being in control of that meeting because it gives me, I probably shouldn't have control of that. But I might. Let me think on that. I mean, maybe I get an independent Kroll person to do it that really knows nothing about DeFi payments at all, but is someone that is capable of conducting a meeting like that.
It just needs to be someone who knows how to respect everyone's ability to freely communicate and not robbing
I think that's probably the best way to do it. Let me work on that.
All right, fair enough. I will cede my time to the others. Thanks for the discussion.
Yeah, no problem. Thanks, Bill. Rob Tuck, you're the last one.
Yeah, it's me, Joseph.
Oh, hey Joseph, how are you?
Pretty good. How can you explain this $750,000 a month for the CPA arbitration? I mean, I'm not an expert, but I've never even heard of such a high rate.
It's not unusual, Joseph. Like I've done litigation's awful. Expert witnesses are needed, counsel's needed. It's all been monitored by the CR and heavily questioned. We got quotes at the start and from multiple firms and then discounts, but it's an important claim and it needs to be run well and won. And unfortunately, they're just expensive.
How long is that projected to? I know you say 6 months. Okay, that was my other question. Was you 2 months ago you said that you expected a resolution of CPA in 6 months, and today we say 6 months. So did it extend your expectations?
I'll take that one, Jason.
Sure.
Yeah, it did, Joseph. I mean, ultimately, these are expectations. They're entirely contingent on the progress that's being made in this process. I can't comment much on the process, but recent developments have indicated that it's going to take a bit longer for this to bottom out. This is not within our, and it's not entirely within our control either, right? This is an arbitration, and as such, it's a process between two parties and the tribunal.
All right. Well, in the last town hall, you said that the increased arbitration cost was due to reaching certain I think Jason called them mile markers or milestones in the arbitration process. In other words, it's coming to an end. So now we have an extension. Does that mean the 750 is going to keep on rolling and rolling and rolling? Or is
let me put it that way without saying anything. Sorry, I was just eating. Without saying too much, you can infer from the costs that yes, a milestone was reached, and you can expect it to reduce significantly from here on in.
Okay. I've noticed, it could be my imagination, but it's not my imagination. I mean, it's a fact that the messaging, obviously the messaging changes because the facts change, but the messaging has changed from the very beginning, pre-scheme, from, we have a good, we're going to get the money back because Darshan loaned him. These are your words, Jason.
Yeah.
Paraphrasing. We're going to get the money back. We will win the arbitration. But I think we're going to get the money back because it's, Darshan did loan him the money, or did loan them the money. Then it went to, most likely we're going to get the money back. we're going to win the arbitration. And then it went to, if we win the arbitration, we might have to go.
I can jump in, Joseph.
Just let me finish. I'm almost done. I'm not going to say, I'm not dragging it out. We might have to go into an enforcement, some type of enforcement. And now George's words today were that we fully expect to win the arbitration, and we fully expect to then go into some type of indeterminate length enforcement action. So what's going on there?
So sorry, Jason, I think I need to jump in quickly before you do that. I may be very much mistaken. It is a late hour for me, so forgive me if I get this wrong, but I don't believe I mentioned earlier that we were going to win it.
Okay.
And I think in line with our current thinking.
Go ahead, I'm sorry.
As we have communicated previously, enforcement proceedings, in our view, are likely to be undertaken and required. Of course, I may be speaking differently from what Jason has, so I'll hand over.
Yeah, I mean, I have a high confidence of winning, Joseph. The question has always been about how much. There's some very complicated arguments in respect of that. So I do think we will be successful in getting a judgment. It's a judgment for how much is a bigger question. And I'm not changed from my position that I've said way back in the scheme that through the conduct of the counterparty here indicates to me that we will probably have to take enforcement proceedings. That's not a given, right? I hope to God that we get a judgment, it's a high one, and we get paid. But it may be necessary to take enforcement steps.
Can you give me like an example of what that looks like?
Yeah, absolutely. Yeah, absolutely. In very clearly, I can as clear as a piece of how long is a piece of string. But we receive a judgment. We say please pay. They send us the money. We're done. They don't send us the money. Our immediate next step would be to issue a statutory demand to them to say pay us the money within 21 days. When they don't, we can then file a winding up petition in court against the company that is a counterparty to the contract. If the company at that point doesn't pay, that company enters into liquidation. A liquidator is appointed, somebody chosen by us, and that liquidator then can investigate that company and establish why it can't pay the judgment and whether it has assets, whether there is any assets dissipated in prior years that could be subject to clawback and try and get that money back and then pay the judgment.
And how long does that process like that?
Well, that's the how long is a piece of string, right? Like you don't know until you get there. So the winding up part of it, not that long, 21 days for statutory demand, file it with the court, probably 2 months for that. So say 3 months for that process. But then once the liquidator's in, well, you don't know what he's going to find until he gets there. And you don't know whether he's got any actions to make or what he can do. But the honest answer there on the downside is he might have it might be easy and it might work out. And within 3 to 6 months, he's recovered funds that can then pay us. Or the downside is it can take years because those actions can be complicated, and particularly in crypto world, and particularly with a counterparty that's had a couple of years to, dissipate assets if that's what they wanted to do. So it can be a long, expensive, drawn out process.
Well, I mean, how is that addressed in the scheme?
Whenever we talk about the risk of that claim, basically, what I've just said is not new. I have talked about that enforcement.
Of course,
risk,
what I'm asking is it's a 3-year scheme with $10 million. $10 million cost.
Oh, we would extend the scheme for that purpose. As long as there's reasonable prospects of recovery, the scheme can be extended.
No, where do you get the money from?
We at that point we probably don't need any money. Like let's assume everything else is done, right? Collected CoinLoan and FTX and whatever, and paid it out. There would be some interaction from DeFi to pursue that claim. Let's assume that all happens before it, and the company enters into liquidation before the end of the scheme. Then it's over to the liquidator, basically.
Okay.
You know, now there's questions of funding there, right? Does he have money? Does he need funding? Do we fund him? Where does the money come from? Do we hold back creditor funds for that purpose? There's some complications, but you know, if there's a valid recovery and prospects that we choose and creditors support to pursue, then we will be able to extend the scheme for that purpose.
Okay.
Hey, Joseph, can I ask, sorry, Joseph,
Sure.
would that claim on counterparty A be a secured creditor claim, or we would be in line with the other creditors, you know, like a liquidation?
In line, unsecured.
Oh, that's not good.
Well, and we don't know. We
Just
have
drag
no,
on like, you know.
we have no idea if there are any other creditors, MJ. So all of that enforcement part is unknown because it's impossible to get information about that counterparty until you get to that point.
I understand, but I was just adding to
Yeah.
Joe's point that, you know, how long it could drag along. I mean, we could get into another liquidation, which could drag along for multiple years, you know.
Look, it's certainly possible, guys. I can't say anything otherwise, but we're not focused on that. We hope we will win, and we hope we'll get a settlement or receive the proceeds. There are also reasonable prospects of that, right? So it's not all doom and gloom, but I can't promise either way.
I guess my point and Joseph's point is basically we're looking at the worst case scenario. That's all.
Worst case scenario is horrible, MJ.
Yeah.
We win. We have to enforce. We believe we have valid efforts. We borrow. We keep back creditor funds to fund that enforcement action. We fund the liquidator to do it. It takes 2 or 3 years, and we get nothing. I mean that is the very worst case scenario.
Gotcha.
Yeah, and just one question on the arbitration, right? I've been involved in the arbitration with Celsius and Voyager recently. Okay. So I don't get it. You know, those were like, you know, quick, like in 1 month, they were difficult, you know, negotiations, but the legal counsel were able to get over what is the legal law and, you know, get over it. I don't understand why this is like,
I think you'll find they weren't arbitrations, but probably mediations outside of that process. And you know, in our particular case, we have a counterparty that its primary focus is to absolutely obstruct and delay. That's their only focus. They don't think they're going to win. They just want to delay. So, you know, we have to fight that. And in your others, I don't know what the situation was, but it sounds different.
got it. Okay.
Okay. MJ asked earlier about increased tech cost or development costs, and then George said that Demir's heading up that. I don't know if he said heading up, but he's definitely participating in the tech and development. So are part of those increase that $7,000 increase a month? Is that have you increased Demir's salary?
No.
So okay, all right.
That's just developers.
All right. What about this? Jason, how do you intend, since you're the boss here, how do you intend on addressing the security issue of this online sales marketplace of secondary claims, or I don't know what you call it actually, but because it's very easy. It's very easy for an unscrupulous person to be part of the board. Forget that. Let me just put it. How about this? People are asking about why Pantera was investing in Darshan. Well, I mean, what if Darshan promised him? What if Darshan has inside information on the secondary market? He knows for sure CPA settling. He knows for sure. I mean, up to date information. You know, minute to minute. that's an easy way to get somebody on board.
Yeah.
You know, that formally got burned, you know, hey, you can buy that claim. I can guarantee you're going to get the money from
Yeah.
that claim. Everybody
Okay.
else is going to lowball the offer. So how do you address this, a security concern like that?
I think KYC is the only answer, Joseph, that is detailed to ensure that related parties aren't buying claims.
Yeah, I mean,
know,
related
I
parties.
know
I mean, it doesn't have to be a related party. I mean, Darshan
I
could sell
know.
information to my mother. You know, my
Yeah.
mother could buy the
No,
claim.
you it's a fair point. It's under consideration, right? And I think what was his name? The earlier creditor's comment was also a very good one, that it would have an impact on the RDA.
James, probably.
Yeah, James. If there's another RDA, it would diminish, you know, liquidity for that, and that was the reason why he voted. I think that's also a good point.
Yeah. Well, yeah, in my opinion, I don't want any more RDAs, but I understand the point. Yeah, so I don't know how you're going to address that. So,
I agree with you. That worries me, to be honest, Joseph. This hasn't happened yet, right? It's ready to happen. Demir certainly wants it to happen. He thinks creditors want it to happen. It is good to give creditors liquidity. Everybody's waiting for so long. If it facilitates that's a positive thing.
I mean, if you look at,
yeah,
let me, you know, it seems like we have like a good cop, bad cop situation here. You know, it could be looked at like, you know, you're looking out for creditors' interest, and you have some other people. You know, and I'm afraid to even talk now, honestly, because I don't want, you know, whichever distribution is coming up in the future to be held on to. You know, I know it takes one, you know, or the, you know, don't push the button for 38 BTC because, you know, because he got on, you know, on the wrong side of the fence here. So honestly, I'm afraid of retaliation. That's why I can't. I'm hedging everything I say here. Retaliation by the board against me vis-a-vis my future distributions. And I'm not the only one that feels that way either.
You can
Some
speak
people,
freely, Joseph. You're going to be treated the same as everybody else.
yeah, well, maybe. I mean, I appreciate the sentiment, but I don't even know where I was going with that. But yeah, I forgot even where I was going with that.
No worries. Anything else, Joseph? I mean,
Yeah,
it's sort of really late now.
Yeah, no, but you guys helped me on to the very end. I can't really do anything about that. I've definitely
And I'm
taken
sorry.
time. I've definitely taken less time than everybody else.
That's true.
Position for okay. I want to say this. Yeah, it looks like there's a good cop, bad cops. Like it seems like, you know, you got, you know, some kind of type of problem within the board. I don't know what it is, but you know, the only reason that people like me that want to rock the boat and say, okay, man, screw it. I'll support, you know, Bill Dorfield for Dorfield, however you say his name, for you know, for credit representative, which I mean, he's intolerable. You know, I would, you know, took everything in my power to say that, to put that on, you know, change my mind on this thing. I mean, he should let you speak when, you know, why does he, anyway, it doesn't really matter, but yeah, everybody understands the point. But the only reason that I would even do that, I don't care if Demir talks to me personally or not. I don't care. It's just that there's little markers along the way that just leads everybody to believe that it's all part of a big scam, which I know is very hard. I mean, I don't know how you guys would get away with it. Not to mention, you know, the personal ramifications that, you know, because you got people out there threatening people and stuff, you know. But legally, I don't know how a big scam could be pulled off like this. But for instance, like the 800,000, you know, FTX claim, you know, that just got thrown out there. And I was told something totally different than what you guys are putting forth now. I was told, if I'm not mistaken, it was by Demir, that they were I'm not mistaken. It was by Demir when I spoke with him. They were commingled funds. Basically, it was the 800,000 were just sitting where another party's funds sitting in the same account on FTX as our money. And it never was our money. It wasn't a loan or anything like that. It was just the other party's money just sitting there. In other words, it was like a related party. It was a related party that just had their money there. So, and now that it's a little, I don't even want to get into, I really don't care about, because I can't do anything about it. I try not to focus on things I can't change, but it seems now the story seems a little bit different that's coming out now. I don't even know what the story is now because it sounds like the story changed 2 times tonight. But
I don't think that's right. Like another party put 800,000 into that account with FTX and has a clear right to that money. It's that simple. And it's been reviewed independently by lawyers and by the board, and it is what it is.
Well, that's one of the things, you know, that threw people off. Then you got, you know, Demir's unwillingness just to come and engage. And then you got the replacement of the CEO, you know, it's unexplained, the replacement of the CEO, and then he's unwilling to engage. But I don't blame this Malcolm guy, because I heard his call with Bill. Bill recorded it and posted it, and it sounded super hostile and adversarial. So I mean, he's scary. You got some.
There's no conspiracy, Joseph, and Malcolm's not. He's just trying to do the right thing.
Yeah, I'm just saying that there's these markers along the way that just throw the people that, you know, they're in support of the scheme off of the scheme. And then you got all the, unexplained again, all the highest value creditors are all missing in action. And we know that, we know that CR talks to them personally, because he sent out emails to them. So it just seems like, wow, man, that's what throws people off. That's the only reason people even want to, not people, that's the only reason people like me want a scheme meeting to replace the CR. But honestly, I'm changing my mind on that. I don't even want a scheme meeting to change the CR, and forget it, because it just seems like you're just going to go down a rabbit hole the other direction, and I'm not trying to, I just want my money. I can't get my money back. I just want part of my money back. So,
well, the good news is hopefully soon we can focus on that and give some money back.
I've heard you stress tonight that, that Demir is out there, trying to recover this. So, and the only thing he's not doing is talking to customers. So I don't know why that is. I wish he would just show up in the meeting, and then, because he would catch hell the first meeting, but the second meeting everybody would be cool with him. So
I agree.
I don't really get it, but that's my sentiment on that. All right, man.
Yeah.
Well, thanks for holding the meeting, and I guess we'll.
No worries. I'm sorry it went late again, but that's typically what we end up doing here.
And I'm in Thailand.
I do want to give everybody a chance. So yeah. All right. Perfect.
All right,
thank you, guys. Appreciate all your time. Thanks, George.
All right.
Thanks, everyone.
Bye, guys.
Thank you.